He said he wants self-defense.
And there they are. That didn't take long. That did not take long. All right. Let's see here. Should I do one of these? One of these. Let's see what happens. Hello, Gigi. Good to see you. Hello, everybody over at Rumble. Hello, you at X. We are waiting for closing arguments in the People versus Rendon trial. It was a 3-day trial where the defendant took the stand in his own defense and blew it, in my opinion. Completely blew it. During cross-examination of him, we found out that the only video that was sent to the plaintiffs from somebody. And when that happened, apparently, Mr. Rendon.
Mr. Bloomquist,
Yeah.
if you'll speak with the state on what you would like added to the charges, I'm going to call the docket. All right, everyone, I'm going to call the docket. When I call the docket, you need to stand and let me know you are here. Otherwise, I'm going to assume you're not here, and a warrant may be issued for your arrest.
So, all right, we are listening in from
Leslie O'Banion.
This is how efficient Judge Boyd is. There they are, waiting for the defendant, who is not at the table. And yeah, adding to the charges, that I don't know if apparently this might be allowed under Texas law, but for me personally, that's a load of bullshit. Because the state rested and the defense rested. The trial is done. So, yeah, another one of these weird things in Texas I do not agree with. You can't add charges after. That sounds like they are bringing in possibly middle ground charges. If they don't convict him on the big charge, they might convict him on the lesser. I don't like that. That speaks of weakness from the prosecution. And I do believe they have a good chance of a conviction on the aggravated assault, resulting in disfigurement and stuff. I think they have a good chance of winning that. So bringing in new charges, no, I don't like that. But as I said, the efficiency of Judge Boyd, they are right there. Instead of, like many judges do, let's take a break. No, she calls docket. So let's see what this is.
In custody. Efrain Martinez Soto. Juan Cruz, custody. Thank you. Christopher Mariscal. Humberto Rodriguez. Zoe Brooks. All right. Alfredo Campos, custody. Guillermo Mendoza. Jenny Guerrero, custody. Alex Bacon.
Bacon.
You know what? That may really be the degrees of separation to Kevin Bacon. Alex Russell Bacon.
More bacon.
Veronica Wicks. Carlos Vasquez. Paul Inaosa, custody. David Brown. David Warren Brown. Jonathan De Hoyos. Jonathan Alfonso De Hoyos. Jalen Ross, custody. Is this Stefan Palacios Cruz?
49, Council.
Thank you. Alexandra Hernandez Mejia. Alexandra Hernandez Mejia. Marisol Vasquez, custody. Dominique Escobar. Jalen Ross. Jesse Garza. Ortega. Guillermo. Is this his first or last name?
The Gumar is his first name.
All right. They did the comma wrong. Gamar Mejia Ortega, custody. Bradley Galan. Bradley Tyler Galan. Miguel Velez. Gregory Jennings. Guillermo Mendoza III. Jack Evans. Grace Rocha. Amanda Drummond, custody. Arturo Villanueva is by Zoom. Jamal Fisher, custody. Mario Huwiti. Mario Huwiti, custody. Gerardo Herrera. Gerardo Marino Herrera.
You're on that, Judge.
Thank you. Jesus Santalo. Sergio Garcia. Monica Wade. Thank you. Is there anyone who came in later? Your name was not called. Oh, yes. What's your name? Okay. Anyone else? All right, everyone. These are the rules of the court. We are doing closing arguments this morning. So once all of the jurors are here and the jury charge is completed, we're going to go into our closing arguments. So if you have someone who's in custody, they're not going to be brought out right away because we're going to do closing arguments first. Once the closing arguments are concluded, I'll take up the daily docket as usual. Everyone, you may confer. All right, State, on this case, Rendon, have you had a chance to review the request by the defense?
So I guess there were two things that he wanted to address regarding his proposed instruction. I don't necessarily have an objection to the law regarding presumption being in a jury charge. I would just ask that it track the statute.
Okay.
And then you can address your other point.
On that one, it does track the statute. It just has, it just basically says that,
Okay. All right. So
yes.
we're all agreement. Presumption tracks the statute. And then we'll need to put in the definition of robbery.
I agree.
Okay.
Bro, take a roll.
And defense is saying that they want self-defense and defense of third parties.
Yeah. And over the weekend, just I was considering the evidence. And I was,
Oh, no problem.
yeah.
No explanation needed. I'm just wondering if there are any objections to that.
No, I don't care.
So I was doing research over the weekend, and I think because ag assault is a result-oriented offense, and because the level of force that was used caused serious bodily injury, it is deadly force, and so I don't necessarily believe that they're entitled to the regular self-defense instruction in the charge.
Okay, so I'm sorry. Could everyone please whisper? And we're not on the record yet. I'm just trying to figure out where everybody is and what you want. So I'm sorry. Could you repeat that?
Yeah, so I guess I am objecting to the regular self-defense coming in just because I don't believe that he's entitled to an instruction on self-defense because aggravated assault is a result-oriented offense, and the level of force that was used in this case was deadly force by definition because it caused serious bodily injury. And so I did have some cases that support that. It was Farrell v. State, and I think that just cites if you like.
All right, so here's my question, defense, with regards to his, I see the defense of third parties, I can see that.
Yes, sir.
But with regards to his self-defense, I don't see how you get self-defense for him when it's when it is the complainant that is, for lack of a better term, engaged in some sort of altercation.
And the reason I think it's relevant, Judge, is because it's just like the law of parties for my guy, it's the law of parties for them.
Mhm.
So there's all these people having this melee. There's the other guy that's involved. He's concerned that he may come back. He's got the girl who scratches his neck, and then him as well. So it's basically almost like a law of party situation where he's being assaulted. This whole group is being assaulted by multiple people,
Mhm.
and that's why I think it's relevant, Judge. And then let me just address the issue on deadly force versus force. So deadly force is either force that's known or intended to. And I think it's very arguable that a person would not know. And I actually have some really good examples of that, where police officers use knee strikes to the abdomen, Muay Thai fighters, and this happens thousands of times, and people don't get these kind of injuries. So there's that issue. Also, I think that because aggravated assault with a deadly weapon or aggravated assault, serious bodily injury is a result oriented offense, someone could use a punch, which I don't believe is generally deadly force. A punch would normally be just force. But if the person were to fall down a flight of stairs because of that, they could receive serious bodily injury, even though the force only used was force.
Okay, so what I can tell you is, I think what should go on for my interpretation of the statute and the case law, I think deadly force should be the correct from section 9932. But I'll listen to everybody.
Yeah.
We'll put it all on the record. But
Okay.
based upon my review of the case law and based upon everything that I'm viewing, it doesn't seem that just use of force applies in this case, based upon what I'm reading.
Is it possible to charge both, Your Honor?
No, I don't think that's appropriate.
Okay.
I don't think,
All
I mean,
right.
I don't know what case
right,
law she's
so,
looking at, but a knee
We'll
to
go
the
on the
abs,
record. I'll hear your arguments. If you can have
generally
your client come in,
I've
please.
never heard that used as deadly force or used as an example of deadly force.
Oh, Norma, the charge is going to have to, some things are going to have to be added to the charge. So it's going to be a little bit.
This is strange.
Oh, we're done.
It's on the phone.
I mean, multiple strikes while a person is down. Yes, I can see. But in this case, he put his knees once. This, yeah, this is
Is the
strange.
client here? All right. All right.
Okay. That's fine.
I don't know, Derek.
All right. Who's here on Christopher Mariscal?
I'm here, Your Honor. Mr. Mariscal is here as well.
All right. If you have him
All
come
right.
forward, please.
Morning docket.
And just let me sign into Odyssey. Hello. Thank you for dressing appropriately for court, but you always do. I really appreciate that. Sometimes people don't understand. And I always say they don't understand because they haven't been to court. People always think these are, rules that I'm making up. But in court, there's a standard of dress you have to have. I would always tell my clients, it's okay if you have jeans, but don't do the ripped jeans. If you do some khakis, and I always tell them, we can do a t-shirt, just make sure it has sleeves. I used to tell my clients, dress as though you're going to church. And then one of my clients came dressed as they're going to church. And I'm like, oh my gosh, this is not the way we do in Louisiana. All right, let me see. I can get my Odyssey to behave well. All right, so today is plea deadline date. Do you have all of the discovery?
We do have all of the discovery, Your Honor.
All right, so does your client wish to have a jury trial?
Well, I don't want to run afoul of any of the court's admonishments about agreements and things
Mhm.
like that. I was going to ask for 30 more days to confer with the state. There's some mitigation that I'm putting together. We have a plea offer. We have all the discovery. It's just, I wasn't going to execute it today unless we absolutely had to. I'm still conferring with the state a bit. And
All
I'm
right,
optimistic.
I will give you 20 days.
That would be great. Thank you, Judge.
All right, Ms. Ferguson, I need a 20-day reset. And this will be your final plea deadline date.
Thank you, Judge.
You're welcome.
Hey, American Legend says not everyone has nice clothes because not everyone
All
can
right,
afford
June
nice
2nd.
clothes. Just be clean
Yes.
and bring your
May I
best.
have later in that week, Your Honor?
June 5th.
Yes, thank you, Judge.
All right.
Yeah.
So
Many
this is coming back
lawyers,
on June 5th,
especially criminal defense lawyers,
and that will be your
have
final plea
a
deadline
bag
date.
of
All right, you can have a seat.
shirts.
Once you sign the reset form, you're
Uh,
excused.
just
You're welcome.
to make sure your client doesn't show up in an ACAP
Judge, depending on the
I
age and
have
gender of
t-shirt
the
or
church attendee, you might end up with a big hat.
stuff like that.
Yeah, that's true. All right, who's found Gerardo Herrera? All right, Deputy Laura, could you make an announcement for Gerardo Marino Herrera, please? Yes. Yeah, I just got kicked out of Odyssey. They were like, you're not welcome. Maybe that means I can go home. All right, court is calling 2020 CR 0012W State versus Gerardo Marino Herrera. Can I have parties announced?
Megan Galloway for the state.
Albert Chidas for Mr. Rendon.
All right, this case was scheduled today at 9 a.m. It is now 9:16 a.m. Deputy Laura, did you make an announcement for the defendant?
Yes, Your Honor, I did. He is not out there.
All right, and when the court called docket, the defendant was not in the courtroom, and the defendant still is not present in the courtroom.
Uh-oh.
Defense, have you had contact with your client?
I did back, about a couple of days back, but I haven't had any contact with him this morning.
All right. Court is going to issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. You're welcome.
Judge, I'm not getting any audio. I'm trying to figure this out. Now all of a sudden.
Excuse me, at 7 o'clock Friday night. But I had to give him a credit card. But luckily the coordinator was taking it. Then they did start writing that.
Yeah, first warrant of the day. Second call up. Hey, warrant. But at least it wasn't an automatic with plus bond and everything, but we don't know until that guy gets there. You live in Appalachia. All right, nice. Where's that?
I hate Power more. Oh, I hate. The whole thing is video. That's what they're fighting. I'm pretty sure. It wouldn't surprise me.
Dun, dun, dun. Oh, that okay. Now I know where it is. Now I know where it is. I think I've been there. I went up to Georgia to Blue Ridge and visited the Sasquatch Museum in Blue Ridge, Georgia. It was amazing.
Good morning.
I jokingly say that where I grew up, that's the Swedish version
right,
of the
Cindy.
Appalachians.
Are you ready
I
to go
mean,
on record with that
entire
argument?
the
I'm
the
gonna take this
class
down so it doesn't move on me.
Okay.
my year in school, we had 4
I have
last
no idea.
names, excluding me. 4 last names in 1 year. Now there was only 30 of us. Hmm. Yeah, I mean it's when I went up when I drove up to Blue Ridge, I went through the Trail of Tears, and it reminded me so much of where I grew up, with all the forests, the hills, the mountains, the streams, the little lakes, all that show up all of a sudden. It's a really, really beautiful place.
Cindy, are you ready?
Gonna have to go.
Okay. CR 2338B, State versus Mariano Rendon. Can I have parties announced for the record?
Evan Galvin, Jason Garahan from State.
Larry Blomquist for the defense. I'm here with my client, Mariano Rendon.
All right.
All right,
So there's,
here we
we're
are.
here on the charge conference and state it's the court's understanding that you are not going to ask for the law of parties.
That's correct.
All right, and defense. There are 2 points you wanted added to the charge, is that correct?
Yes, Your Honor.
All right, what are you requesting?
So I'm actually requesting a couple different things. So one, I'm asking that we continue to keep the law, both 9.31 and 9.32 in the charge. I believe that, that's how we had it, yesterday. I believe that's appropriate because in this particular case, the force used was an E-strike, and I believe that that is usually just force, although, and the jury could believe or disbelieve that it caused serious bodily injury. There's testimony that other things can cause that. So, the jury could easily find that he used force and that no serious bodily injury was created. And so I believe that it's appropriate for the court to charge on both 9.31, self-defense, including force, and 9.32, self-defense, including deadly force. I think it's cleaner if the court charges it both ways. In addition.
All right, just 1 second. Let's address that first issue.
Yes.
State.
So we have no objection regarding the 9.32 deadly force instruction. The state is objecting to the 9.31 non-deadly force instruction, and the defendant is not entitled to an instruction regarding non-deadly force because the victim sustained serious bodily injury in this case. We have witnesses testifying to that, and the cases that support that position are Farrell v. State. The site is 55 Southwest 3rd 586. Denman v. State, site 193 Southwest 3rd 129. And then Wood v. State, site 271 Southwest 3rd 329. And specifically in Farrell v. State, the holding was that the court did not err in refusing to give an instruction under 9.31 when the force used caused serious bodily injury. And then in Bentley Beach State, the holding in that case was that the reviewing court would set the end result of the act, and if the facts are that the victim dies or suffers serious bodily injury, then by definition, the force used is deadly and the appropriate instruction would be under.
I would just point out that in this particular case, that it wasn't where we had somebody who was obviously received serious bodily injury on the scene. I mean, they actually walked away, left the scene. So I think there's a real argument about whether actually this incident caused serious bodily injury. And that's, I think, a fact for the jury to decide. And I think also, and because of that, because the jury could find that his actions did not cause deadly force. It's not like a stab wound or a gunshot. It's a thing that happened 2 days later when he reports to the doctor. And we talked about, the doctor testified about all these other things that could cause ruptured intestines. So based on that, I believe that a jury could find that the use of force was just force.
All
not
right.
deadly.
So defense, your instruction under 9.31 will be denied. The instruction given under 9.32 will be allowed. All right, and next, what's your next request?
I filed with the court, I gotta sign those, but I filed with the court our requested jury instructions and our requested jury instructions on the presumptions. There's evidence in this case.
All right, and so my understanding is that the state is not objecting to presumption, so
That's
that will
the
be
only-
in.
That's the only other thing I have.
All right, so
Other
the,
than that, I'm satisfied. with the charge.
all right, so the presumption will be in, and then what will be included then is the full definition for robbery. All right, is there anything else?
No, yeah.
All right, I'll have the charge writer
Okay.
send us that information. And if there's no objection, I'm going to send her an email to what you all both have agreed on so that she can add it to the charge.
That's fine.
All
The
right.
other thing, just for clarification, for my clarification, we discussed whether that we were gonna give 2 paragraphs, one on self-defense, one on just third party. So the third party, did the court decide on that?
Well, did you want to argue
Yeah.
the defense of third party?
Well, obviously, I think defense of third party,
I'm sorry,
Yeah.
I'm sorry, excuse me, the defense of third party for the court's review of the evidence, that should be in there.
of course.
So if you can address your request
Yeah.
for self-defense.
So why I'm also asking for the well, obviously, I think self-defense instruction has to be included because the third party defense refers back to it. Because it says that basically has to be authorized under 9.32 to use the force. I think that should be in the instruction regardless. And then the second thing is that in this particular case, there was this melee that occurred. There was multiple people attacking multiple people. And my client did have injuries from that. So almost like a lot of parties on going the opposite side, my client had a scratch on his neck and was assaulted during the commission of this melee. And so therefore, I think he's entitled to a self-defense instruction based on that.
All
We
right,
did have evidence of that assault by the photographs of the injury to his neck.
all right, and state with regards to the defense's request for self-defense.
So regarding it being in the charge, I guess I would just object to the application paragraph of it. I agree that it should be included in the defense of the third persons, but I would just reiterate.
All right, any final argument?
Yeah, I mean, I think the fact that he was actually injured during the assault and he did testify about being assaulted by Esperanza Garza, who was assisting Pablo Rodriguez in the assault that occurred on the security officer. I believe that that's sufficient for us to get an application period on both.
All right, the court will allow the defense's request for self-defense in the charge. All right, is there
All right.
anything else from either side with regards to the charge?
No, Your Honor.
No objection.
All right,
So,
how much time are you all requesting? We can go off the record.
I think about 40 minutes, Your Honor. It looks skeptical.
20 minutes,
Let's split this and call it 30 minutes. Your
19 minutes?
Honor. I'm obviously gambling with the house.
All right, so what I'll do is I'll give each side 20 minutes. If y'all end up going over a little bit, I won't interrupt you. Does anyone request a time announcement?
Fine.
All right. So the added
There's
charges.
another judge who would have given you all 5 minutes for closing argument.
So the
All
added
right, everyone,
charges is
because we're waiting
yes.
for the charge, if you have someone who's on bond and you all have conferred and you're ready.
So the added charges is defense of third party, as in the defendant brings up he was defending the security guard who was on top of the plaintiff, and apparently somehow also self-defense in itself. Not entirely sure, but the state didn't object, and it seems like I didn't hear the state actually adding more charges themselves. So all the things that got in are for the defense. Okay, that was interesting. Did not expect that. Did not expect that. All right, this and 20 minutes each for closing arguments. This is standard for Judge Boyd. I've seen several trials with her. If it is just if the trial is less than a week, as in this case, 3 days, and not just 3 days, 3 half days. She gave them 20 minutes. Same with the other trial I covered a while back. Let's see what. TK, the TK trial. She gave 40 minutes, I believe. The state got 40 minutes combined for closing arguments and rebuttal, and the defense got 40 minutes, and they took 20 minutes each. And the second attorney, the 82-year-old attorney, fucked up, and she just stopped him cold in the middle of his argument. So let's see.
Ready? You may approach. Hello, hi, who do you have? Oh, okay. All right, thank you.
Interesting.
Okay. All right. Okay, all right, thank you. No problem. Alex Russell Bacon. Alex Russell Bacon. David Warren Brown. David Warren Brown. Alexandra Hernandez Mejia. Alexandra Hernandez Mejia.
May I be excused to go to another court?
Yes.
That's fine.
Yeah, okay.
I'll come back and make sure.
All right, thank you. Bradley Tyler Galan.
Council President, Your Honor, I believe Mr. Galan was allowed appearance on Zoom.
All right, and he hasn't, let me see if he's shown.
I don't know if we provided him with Zoom.
Yeah, he's not here yet. If you'll let them know. But I see the following: Arturo Villanueva. And State, are you ready to proceed on restitution on Villanueva? It's a failure to stop and render aid.
Let me see where.
Okay, sure.
All right. Failure to stop and render aid. Didn't know that was a thing in Texas. Why didn't he stop? Well, he is 121 years old to start with.
All right, so defense, Daniel Vela.
Or is Villanueva?
I'm here.
All right, have you had a chance to speak with the state on the restitution?
No, I have not, Your Honor. I would love to.
All right, State, Mr. Vela, I'm gonna put you in a waiting room. And if you can either call him or if you want to appear on Zoom to speak with Mr. Vela, it's concerning Arturo Villanueva.
Yes, sir.
All right, I'll put you in the waiting room with, and your client in a waiting room, and the state will speak to you.
Okay, so we don't get to hear that. Darn it. Okay. No, they are just waiting for the jury now, so they can commence the closing arguments. All right. Gigi says, if you see a car accident in Texas, you're supposed to stop and help. If someone gets your plates driving by, you can catch a charge. Did not know that. I don't know how much help I could give because I can barely walk. I walk with a cane because I have arthritis in both knees. But I can stop and I can call 911. Well, it depends on the severity of the crash. If it's just somebody who drove off down to the ditch, if it's a water ditch, yeah, I'll do what I can, but I really can't do that much. Unless it's anything I can do with my upper body, I'm quite useless. Now, if I can grab onto something and grab on there and pull out, that I can.
It's just one. Thank you. Thank you.
I mean, it's bad not stopping to help in some way, but a crime? I don't know. We don't have that here.
Yeah.
Cindy, do you need IT call down?
I might. Just
Could you call IT down, please? Thank you.
Never heard of not having those laws. Well, Europe is a bit different. We have a lot of roadside carjackings over here. Not as much in Sweden, but on the continent, mainland Europe. People who act hurt, and then all of a sudden, hey, your car is driving off.
Cindy, is it your audio? Your equipment?
It's my audio. So. It's working now.
So, Karen Reed trial is
Oh, normally you can
ongoing,
cancel it.
and the Diddy trial have started. No wonders I have low numbers today, but I've had low numbers before. I'll keep on doing this. I started a trial watch clips channel, by the way. Let's see if I can get that up to dun, dun, dun. Here is that one where I do clips from George Boyd, George Simpson, all from tiny videos to entire days. I will publish there because I realized that if I get successful videos on this channel, my main channel, my live streams suffer and vice versa. So I'm trying to differentiate my clips from my streams. And slowly but surely, I will start posting more and more on videos on my Clips channel. So if you wouldn't mind, go over and subscribe to that one. And that is because this channel will be eventually streams only, live streams only. We are waiting. And we are live.
So we.
We caught
Yes.
up.
Brooks.
Which case is this?
Gregory Jennings.
All right, can I see the file on Gregory Jennings, please? All right, how are you doing? Oh, I'm doing okay. Thank you so much for dressing appropriately for court. So my understanding is the state has filed dismissal in your case for insufficient evidence. So I'm going to sign it. Enjoy the rest of your day. All right, you're welcome.
Thank you, Judge. May we be excused?
Yes.
Hey, congratulations, Mr. Name I didn't catch. How about that, Mr. Brennan? You can dismiss a case if you have shit evidence.
Oh, yeah.
Cheers. Deputy Laura, are all the jurors here? All right, thank you. All right, Zoe Brooks. All right, Yaya should be printing out the jury charge and then we'll start right up. All right, you need to make sure that you're on time for court, you understand? And no gum chewing. All right, so, State, were you able to attend an offer?
No, Judge, it's sort of a preliminary review. It's three different cases. It's
Okay.
all ag robberies, but they're all different ones.
Ah,
So we do need to get we've got a hold of one victim, just not the other two right at this moment.
all right, so defense. State is currently in jury trial. Normally, I don't set this past 30 days, but do you have any objection to a 45-day reset?
Judge, I wouldn't object to 90 days.
All right, 44 days.
I heard the negotiations earlier. I'm gonna stop where I'm at.
Okay. Norma, if I can have a 45-day reset, please.
26.
All right, is June 26th good for everyone?
Should say yes.
Yes.
All right, so we'll see you back here on June 26th at 9 a.m. All right, thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you're excused.
Thank
You're
thank you,
welcome.
Judge.
You're welcome.
Well, the farm is doing as expected.
Yeah, the week is the 26th.
Thursday.
The fields have been planted and everything is going smoothly. So we are waiting for the weather to fuck
mission.
everything up. Yeah, for you who don't know, I lease out the land on my farm to a big farmer, a neighbor about a couple of miles away. Now, we like rain, but we like rain at the right time. Especially around harvest time, we don't want rain at all. I mean, a sprinkle every now and then, yeah, that's good. That way we don't have to bring out all the hoses and sprinklers and stuff. And so far this year it's been good. And now it's getting warmer, which is good because everything is growing as it should. Yeah. Yes, Derek. Rain at the wrong time. That could ruin the entire crop. I mean,
I conferred with Mr.
Well-
Graham and Mr. VM.
once everything is
If only he
mature
were here now. He's
for
not.
harvest, you might have 3, but depending on the
All right,
crop,
Mr.
between
Villanueva.
3 and 7 days.
If you can call your attorney and tell him he's needed back in the Zoom.
Okay.
All right, thank you.
Will you pardon me for a moment, Judge?
Sure. All right, Alex Russell Bacon.
Mr. Bacon.
All right, if you'll come forward, please. All right, so you need to make sure you're in time for court, okay?
I'm trying to, we're the last over here for, to go around, part time, how do I dedicate one of the words?
All right, so court starts at 9 a.m., all right? All right, so we're going to recall your case. And Norma, recall this case for, are you employed?
Just basically that, like, last Monday.
Okay, so we're going to recall this for Thursday, May 15th, okay? Once you sign the reset form, you're excused. All right, thank you.
Yeah. Don't be late for a continuance. No, that was not the guy with the warrant. That was another guy, I think. I don't think that was the Bacon guy.
Norma, what case is that on? It doesn't tell me anything.
Oh, which one? That's the long. I mean, that's the bacon case. The email,
Yes,
that's the one with the bacon,
okay, all right, thank you.
the bacon case.
All right, who is here on Bradley Galvan?
Mr. Galan should be logged in on Zoom.
All right, so we have Mr. Galon. You need to start your video. Thank you. All right, so we have a possession case, and then we have a taken certain wildlife case. And the last time we were here with the wildlife case, there was some issue about an appellate
Possession and
ruling.
wildlife. Did you
That's my
kidnap
understanding
a
of the history of the
squirrel,
case, Your Honor.
sir?
However,
While high.
Mr. Gillan recently hired our firm this past week.
Mhm.
We just entered appearance on Friday.
Mhm.
So we haven't had the opportunity to receive, download, and review all the discovery completion.
I want to
I
know
did have a
if he
chance this morning
kidnapped
to
a
review
squirrel.
the state's file
Mhm.
for
While
the
high.
written discovery, but there is still some issues from the history of the case regarding that appellate issue. And I need to follow up with the state on some other discovery requests that were done prior to our entering the case.
All right, this has been going on for over a year now with us awaiting the appellate ruling. Ms. Ferguson,
Yes, sir.
they're gonna need a jury trial date, so if you'll confer with Ms. Ferguson on a jury trial date.
Yes, ma'am.
All right, and then once you have the date, let the court know.
Yes, sure.
All right, thank you. All right, Mr. Gallan, just give us a moment. Yes.
Judge, prior to setting it for a trial, just because I haven't had the chance to confer with the state about any sort of resolutions, we possibly have a plea deadline prior to.
All right, it'll be trial date and plea deadline date, and if you're all gonna enter a plea, it needs to be done before the jury trial date.
Yes, ma'am.
All right, thank you.
Thank you, Your Honor.
You're welcome.
Brad, I want to know, did you kidnap a squirrel while
No,
high?
We're still awaiting the attorney. And
Yes,
I'm gonna go in the back right quick and check to see if the documents have been printed off. Yes,
I
thank
want
you.
to know, what did you do?
All right,
Possession
so
and
July 22nd is gonna be your
wildlife.
jury trial date.
Yes, Your Honor.
All right, thank you.
And I'll make sure to get as much as I can.
All right.
Thank you.
All right, thank you. You're gonna need to be in court on July 22nd for your jury trial.
July 22nd.
Yes,
All right,
They
thank you
will
for
have,
dressing appropriately for court.
yes, ma'am.
All right, you too.
I will try, really try to, but because they will have several meetings with Judge Boyd before trial starts, with discovery, with motions, with anything, or even a plea deal, maybe. And I simply want to know, did he, while high, kidnap a squirrel? Or was it one count of taunting a kangaroo at the zoo, as American legend says? All right. Have the jury arrived yet? Okay, some news from the, news. The Karen Reed trial is going on. Sergeant Bukaki is still being cross-examined. And according to bedroll law, says Buchanan is really going to say that's what it says without considering the contents of the text of our fact. He continues to say, this is a complete disgrace, and the Massachusetts State Police should be ashamed of itself if this is how their supervisors testify. This attempt to parse words and avoid admitting undeniable facts is pathetic. Yeah. On top of that, folks, we learned that Sergeant Supervisor Yuri Buchanan has a salary, base salary of $211,000 a year. Base salary. Yeah, if you wonder what your tax money gets you in the great states of Massachusetts, they get you Sergeant Bukaki. Yeah, the previous guy. Yeah, the squirrels probably tried to kidnap him. What else is going on X? Yeah, Brennan filed a motion that he now, despite what he claimed for months, that he was not going to bring in Aruba, he will bring in Aruba. Oh, hello.
All right, I cannot complain. It's a beautiful day.
Say about that, I mean,
Mr.
Oh,
English is
oh
here.
no. Hello, morning.
Conferred. It made us.
Yes, to pull the file.
I'm sorry.
That's okay.
Ah, Mr. Villanueva and Daniel Vela.
All right, Jonathan De Hoyos, come forward. And counsel, you received all discovery
We have received discovery on this matter, Your Honor.
and you said an offer has been tendered.
Has been relayed to us, Judge.
How old are you? All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date.
Judge,
You're welcome.
may we be excused?
Oh, you haven't got your date yet. All right, so we're gonna come back on June 10th. On June 10th, you'll need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next court date is jury trial date. You understand? All right, and thank you for dressing appropriately for court. Just have a seat and your attorney will bring you the reset form. Thank you. All right, so we're here on Arturo Villanueva.
Yes, Judge.
Oh, thank you so much.
Make sure it's a good phone number because they're gonna call you on that.
So have you all,
Okay, now this one's an email address. Make sure this is
Agreement.
the-
restitution?
We have not, Judge.
All right, are y'all ready to proceed?
We are not, Judge. The request that the complainant will make, I suspect, will require additional documentation.
The address you gave, 73191.
All right, defense, they're asking for 2 weeks to provide documentation. Any objection?
Judge, I mean, my client would like to get this issue resolved. I mean, I'd like to go forward today.
All right, so Mr. Villanueva, what I can tell you is this is the last reset that the court is going to allow for restitution. State if you're not prepared with the restitution hearing at this next court date, then there's not going to be any restitution.
I understand.
Ms. Ferguson, I need a 2-week reset for a restitution hearing, and Mr. Villanueva, you can appear by Zoom.
Thank you, Your Honor.
I'm sorry, when? All right, so it's going to be May 27th. And Mr. Villanueva, I'll notate that there will be no more granting of state's requests for continuance as it relates to restitution, okay? All right, thank you. Have a good day. Thank you for dressing appropriately for court.
No. Oh, Mr. Jingles.
All right, you may be excused. And Bashan, that will be the last restitution we will have on that case. All right. We're on the record in 2024 CR 2338B State versus Mariano Rendon. Can I have parties announced for the record?
Megan Galloway and Jason Garrett have received.
Larry Lundquist for the defense.
All right, here we go.
All right, so the
looks like
court
we
received the final charge.
finally,
Have both parties received the
an hour
final
late.
charge, and is there any objection?
We'll have the closing arguments. Mr. Jingles, what's going on?
Jack still request the self-defense or the 9.31 instruction, but other than that, we're satisfied.
All right, are both parties ready to proceed with closing?
Defense ready, Your Honor.
All right, so each side, you'll have 20 minutes. I'll give you a 5-minute warning. Is there any equipment that needs to be set up?
Yeah.
Yes. Sometimes it works, sometimes it doesn't.
Yeah, we're good to go.
Okay, awesome. All right, everyone, y'all need to make sure your cell phones are off. There's nothing worse when you're in your groove, you're doing your closing argument, and somebody's phones goes off. So let's not do that.
All right. You're very cuddly, Mr. Jingles. What did you do? Did you barf in my bed? No, 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 no. No knees. What in the... I want to know what you have done to be this cuddly. You either barfed in my bed, you hid a rodent under the bed, which I will learn by the smell of it. What did you do?
We're ready.
All rise for the jury.
Here we go. I will put up a poll. Just, well, state starts, then defense, and when the defense is roughly halfway, I will put up a poll on what you believe the jury will find in this case.
All right, ladies and gentlemen, thank you so much for your patience. As you can see, there are other people in the courtroom today. It's unrelated to this case. Each party is going to have a chance to do their closing arguments to you. I'm going to read you the jury charge, or what's called the charge of the court. You do not have to memorize it. You will have the original with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Mariano Rendon, stands charged by indictment with the offense of aggravated assault alleged to have been committed on or about the 20th day of August 2023 in Bexar County, Texas. To this charge, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault if the person intentionally, knowingly, or recklessly causes serious bodily injury to another. 2, bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 3, a person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards the substantial and unjustifiable risks that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4, justification defense of self-defense in defense of a third person. Self-defense. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another, 1, if the person would be justified in using force against the other in the first place, as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. The use of force against another is not justified in response to verbal provocation alone. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including a death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person, 1, who has a right to be present at the location where the deadly force is used, and 2, who has not provoked the person against whom the deadly force is used, and 3, who is not engaged in criminal activity at the time deadly force is used, is not required to retreat before using deadly force. If all 3 of these factors are met, then in determining whether such actor reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. A person has a right to defend from apparent danger the same extent as he would had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him from his standpoint at the time. When a person believes, as viewed from his standpoint, that he is in danger of an unlawful attack or a threatened attack at the hands of more than one assailant, he has a right to defend himself as instructed herein against either or all of them. You are instructed that the defendant's belief that the deadly force was immediately necessary is presumed to be reasonable if the defendant, 1, knew or had reason to believe that the person against whom deadly force was used was committing or attempting to commit the offense of robbery. 2, the defendant did not provoke the person against whom the force was used, or if he has, the actor abandoned the encounter. And 3, the defendant was not otherwise engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the force was used. The presumption of reasonable belief applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the jury must find that the presumed facts exist. If the jury has a reasonable doubt as to whether the facts giving rise to the presumption do not exist, the presumption applies and the jury must consider the presumed fact to exist. Even if the jury finds that the state has proven beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged in the indictment as instructed in this charge. A person commits the offense of robbery if, in the course of committing theft of property and with intent to obtain or maintain control of the property, he intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of theft if he unlawfully appropriates property with the intent to deprive the owner of property. In the course of committing theft means conduct that occurs in an attempt to commit, during the commission, or in the immediate flight, or after the attempt or commission of theft. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended. Appropriation and appropriate mean to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent. Property means tangible or intangible personal property or documents, including money that represents or embodies anything of value. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by deception or coercion. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the person charged. Defense of a third person. A person is justified in using deadly force against another to protect the third person if, one, under the circumstances as he reasonably believes them to be, the actor will be justified under the law of self-defense as instructed above and using deadly force to protect himself against the unlawful deadly force he reasonably believes to be threatening the third person he seeks to protect. And two, the actor reasonably believes that his intervention is immediately necessary to protect the third person. The defendant is not required to prove self-defense, and the defendant is not required to prove defense of a third person. The state must prove beyond a reasonable doubt that the defendant did not act in self-defense and that the defendant did not act in defense of a third person. 5. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 20th day of August, 2023 in Bexar County, Texas, the defendant, Mariano D. Rendon, did intentionally, knowingly, or recklessly cause serious bodily injury to Pablo Rodriguez Salazar by striking Pablo Rodriguez Salazar with Mariano D. Rendon's hand, or striking or pushing Pablo Rodriguez Salazar with Mario D. Rendon's knee, then you will next determine whether the defendant acted in self-defense or in defense of a third person and proceed to paragraph 6. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty and do not consider paragraph 6. 6. Now, keeping in mind the instructions regarding self-defense and defense of a third person given in paragraph 4, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the charged offense of aggravated assault, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense and whether the state has proven beyond a reasonable doubt that the defendant did not act in defense of third person. Self-defense application. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the offense of aggravated assault as charged in the indictment, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reasonably believed, that Pablo Rodriguez Salazar was using or attempting to use unlawful deadly force against Mariano D. Rendon, and 2, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reasonably believed, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Pablo Rodriguez Salazar's use or attempted use of unlawful deadly force, and 3, Mariano D. Rendon's use of deadly force was not in response to verbal provocation alone, then you will find in favor of the defendant on his claim of self-defense and acquit the defendant, Mariano D. Rendon, and say by your verdict not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the offense of aggravated assault, and you further find from the evidence beyond a reasonable doubt that one, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, and is not presumed to have reason to believe, that Pablo Rodriguez Salazar was using or attempting to use unlawful deadly force against Mariano D. Rendon, or two, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, and is not presumed to have reasonably believed, that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Pablo Rodriguez's Salazar's use or attempted use of unlawful deadly force, or three, Mariano D. Rendon's use of deadly force was in response to verbal provocation alone, then you will find against the defendant on his plea of self-defense, but next consider whether the defendant acted in defense of a third person as instructed below. Defense of a third person application. Keeping in mind these instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the offense of aggravated assault as charged in the indictment, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, one, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reason to believe, that Pablo Rodriguez Salazar was using or attempting to use unlawful deadly force against Anthony James Cochran, and two, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reason to believe, that his use of deadly force and the degree of deadly force used were immediately necessary to protect Anthony James Cochran against Pablo Rodriguez Salazar's use or attempted use of unlawful deadly force, and three, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reason to believe, that his intervention was immediately necessary to protect Anthony James Cochran, and four, Mariano D. Rendon's use of deadly force was not in response to verbal provocation alone, then you will find that the defendant, Mariano D. Rendon, acted in defense of a third person and acquit the defendant and say by your verdict not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the offense of aggravated assault as charged in the indictment, and you further find from the evidence beyond a reasonable doubt that one, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, as is not presumed to have reason to believe, that Pablo Rodriguez Salazar was using or attempting to use unlawful deadly force against Anthony James Cochran, or two, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, and is not presumed to have reason to believe, that his use of deadly force and the degree of deadly force used were immediately necessary to protect Anthony James Cochran against Pablo Rodriguez Salazar's use or attempted use of unlawful deadly force, or three, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, that his intervention was immediately necessary to protect Anthony James Cochran, or four, Mariano D. Rendon's use of deadly force was in response to verbal provocation alone, then you will find against the defendant, Mariano D. Rendon, on his plea of defense of third person and find him guilty of the offense of aggravated assault as charged in the indictment. As you were instructed during trial to ensure that the jury, the court, and the parties are all receiving the same testimony, whenever a party or witness does not speak English, the services of an interpreter are employed. You are instructed that you, as the jury, are to base your deliberations on the questions as they came from the attorneys in the English language and in the responses from the witness as they came from the interpreter in the English language. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You're instructed that the statements of counsel made during the course of trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to reach a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous verdict, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty, nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. State, are you ready to proceed?
Yes, Your Honor.
All right, you may proceed.
Whatever it takes. This is the defendant's philosophy of how he runs Volcan and what he will do to somebody if he perceives them to be doing something that he doesn't agree with in his club. Ladies and gentlemen, you've heard all of the evidence in this case, and I'm going to talk to you about the elements of the offense. These elements have essentially been stipulated to by the defense, and really what we're going to be talking about is the justification and whether the defendant was justified in his actions or not. I submit to you that he was not. But regarding the elements of the offense, we have the offense date on or about August 20th of 2023. You heard multiple witnesses come in and say and testify to this date. You saw Officer Salas. He testified that he showed up to Volcan on that day. You heard from the witnesses who said that they were there at the club on that day. In Bexar County, you heard from multiple witnesses that this assault occurred at Volcan, which is located here in Bexar County on Ingram Road. Regarding the assault, intentionally, knowingly, or recklessly. And so you have the mental states and the definitions and the jury charge, and we'll talk about that further later, and then causing serious bodily injury to another. You all heard from Pablo Rodriguez Salazar. He took the stand and he testified about the injuries that he sustained, about the extensive hospital stint that he had to undergo. And you all also heard from Dr. Gunst, who testified to the serious bodily injury in this case. And at the conclusion of this case, we will be asking you to find the defendant guilty as charged of aggravated assault causing serious bodily injury. And we reserve the rest of the time.
All right, defense.
Ladies and gentlemen, jury, first of all, I want to just thank.
That was a very, very short closing argument from the state, and that is because she's saving everything for rebuttal. Because now the defense are going to use their 20 minutes, and she will have 17 minutes to rebut whatever they are claiming. That's a very interesting tactic.
Thank you for your time and attention to this case. It's important to state. It's definitely important to Mr. Rendon. This is a terrible situation, and I'm sad that Pablo Rodriguez was injured in this incident, and Mariano is too. Unfortunately, Pablo Rodriguez and the people with him caused a dangerous situation to occur in El Volcan that night. They assaulted Anthony Cochran. They began this melee, which got out of control. Mr. Cochran is injured. You've seen the photographs of Mr. Cochran. This horrible thing happened because Pablo Rodriguez and the people with him drank too much and were angry and combative. I lost my clicker. Forgot it. So this is my clicker. He's not doing a very good job. Okay. So we talk about it. So this case is really about a couple different things. It is about self-defense. It is about defense of a third person. And what's understanding and understand what we're here to do today is basically this occurs in just seconds. The assault occurs, and you heard from both Krista Porter, you also heard from Mariano, that in just seconds, Anthony Cochran's asking for the beer. This tug of war comes in between the beer. Pablo Rodriguez grabs Anthony Cochran. They end up struggling. They end up going to the ground multiple times. And then all these people pile in. You heard Mariano's testimony, and you heard Chris saying, hey, I was trying to keep these people away. I'm 135 pounds. There's 3 or 4 of them. They're all on top of Anthony. There's nothing I could do. He was trying to help his friend. He just wasn't physically not able to because of the number of people that were involved. Mariano said when he gets over there, he starts pulling people off the pile. He's literally pulling off the pile. And he's very concerned and scared for Anthony because Anthony's in this pile of people. Mariano told you that they were punching him. They had already removed his baton. They'd already removed his radio. And now what's to stop them from removing that firearm? And he talked to you about how he saw that as danger. And you're going to see in the charge, there's the thing about apparent danger. That firearm is apparent danger. The fact that they are fighting with him and removing his uniform, and there is a weapon in that pile, that is a dangerous situation. And it's a situation that had that gone and had he gotten that firearm, horrible things could have happened. And because of that, and because of the totality of the circumstances, Mr. Rendon had to step in and defend Anthony Cochran. And he had to do that, and he had the reason to do that. But basically what the law says is that if Mr. Rendon was in Anthony Cochran's position and receiving that assault, could he defend himself? If the answer is yes, and if he has to, he would be justified under 9.32 is the statute to using deadly force to protect himself. So if he was sitting in Anthony Cochran's position, could he use deadly force to protect himself? If the actor reasonably believes his intervention is immediately necessary to protect the person. And obviously in this situation, he felt it was immediate necessary. Why? Because when he gets up there, Anthony's surrounded by these people. They're punching him. They're on top of him. They're taking off his items, and he's got his firearm there. So it's clearly immediately necessary for him to step in and do something. And if you watch the video, and we'll talk about the video being edited a little bit later, in that video, you see, as you watch it, you see Pablo Rodriguez fighting to get back to his stomach so he can get back up. And so this is clearly a dangerous situation, and Anthony Cochran has his hands and is holding Pablo Rodriguez, but Pablo Rodriguez is holding him as well. So it's obviously reasonably necessary. We talk a little bit about it. We kind of talked about this. Pablo Rodriguez is doing 2 things during this assault. Okay, one, he's creating this incredibly dangerous situation where he's physically assaulting him, causing him, Anthony Cochran, bodily injury, but he's also causing, and again, when we have multiple attackers, like in this case, where we have multiple people attacking him, that danger level goes way up. And then also we have the danger, and then there's also this robbery that's occurring. And you heard Chris, the porter, talking about how he saw Pablo Rodriguez tugging on the radio of Anthony Cochran and stripped it off of him. And we know that eventually it's stolen and transported to another location. And that is a robbery, literally a robbery. It is a theft from person using violence, and that is a robbery. And there's a deadly force when we talk about look, I don't think it was Mariano Rendon's intention to use deadly force. I think he was trying to do what he felt that he needed to do to stop this man from fighting, possibly getting to his feet or getting the gun of Anthony Cochran. Okay. I don't think in his mind he's thinking, I'm going to use deadly force. But deadly force, understand, is it's a result of the offense thing. So, for example, if I punch somebody, that's not normally deadly force. But if I punch somebody and they're next to a stairway and they take a bad step and they fall down the stairway and they receive serious bodily injury, then that is deadly force. Even though it's the actual intent is just to throw a punch, it's more of like the consequence of what happened. And that's why we're talking about that, is just because there's this allegation of serious bodily injury. So if the court, when we talk about this presumption, so there's a presumption in the law that says that if you believe that a couple things happen, if you believe, first of all, that Mariano Rendon did not create the difficulty and provoke the difficulty, that he did not, absolutely. Pablo Rodriguez created the difficulty. Mariano Rendon was just responding to it. Second, that he's not doing any kind of crime other than like a traffic offense. And the reason they have that is because they don't want drug dealers basically saying, oh, he came to rob me for my drugs and I'm now defending myself. No, and at this time, what is Mariano Rendon doing? He's in his bar doing the bottle collection. He's not violating the law. And then third, that he is aware that they're and trying to prevent a theft, or I mean a robbery. And a robbery is that violent taking of the radio by person. And obviously he is doing that. So the state would have to disprove beyond a reasonable doubt that that did not occur. And they're not able to do that because we know that that occurred from the testimony that occurred. So what do we have? So we have this presumption, and that means that you have to find, if you believe those three things, if you believe that Mariano Rendon was aware of the theft that was occurring and trying to prevent it, or the robbery that occurred and was trying to prevent it, and you believe he was not provoking the dispute and he was not committing any crime when he did that, then he is you have to presume that his use of in this case deadly force was reasonable and necessary. You have to presume that. You were required to find that if you find those three things. And I would tell you that you have to find those three things because that's what the evidence in this case indicates. So, and this is the robbery presumption that we've been talking about. And you see in this case, it's that you have to find that because of those three elements. So look, when you read the deadly force provision, it talks about three different things. One is, did the person intend or know that what they were doing would cause serious bodily injury? And I would tell you, no, I don't think he knew that. I think that he felt that that was the easiest way for him to comply. I think that he felt that the knee strike to the abdomen was reasonable and necessary to, one, stop Pablo Rodriguez's continuing fighting with Anthony Cochran, was reasonable and necessary to prevent Pablo Rodriguez to get the firearm of Anthony Cochran during that struggle. I think he felt that was reasonable. And I think that he felt that that was going to cause, some kind of pain and also maybe disrupt him enough that Anthony Cochran could get a hold of him. I think also one of the things to remember is that this happens in just seconds. And remember the chaos of this scene that happens. Remember when we watched the video and I pointed out there's a guy in the back of the video that's on the ground who was probably one of the people that was attacking Anthony Cochran. And there's a security or some kind of staff member between him and there. You can kind of see if you go watch the video and if you pause it, you'll see him sitting there or either on his butt or on his knees. That person is still a threat to Mariano Rendon. We also have Esperanza, who is running around pulling at him and scratching his neck and assaulting him. And that gives him concern for his own safety because he's in a situation where he has Pablo Rodriguez, these other three guys that are attacking, and Esperanza, all attacking Anthony, but also attacking him. And he has injuries that indicates that. That's why it's not just defense of a third party, it's also self-defense, because in the totality of the circumstances, he is also under attack. As well as the young man that got his shoulder dislocated. This is a melee, and everyone is in danger while this melee is going on. We see people all the time, Muay Thai fighters using knee strikes to the abdomen. We see this in all kinds of martial arts, and 99% of the time, nothing happens. 99% of the time, there may be some thing, but we don't have serious bodily injury. We see police officers do this all the time. I'm sure if you've watched Cops or any of those shows, you've seen police officers use knee strikes on the abdomen of people. They wouldn't do that if it was going to routinely cause serious bodily injury, okay? But like we talked about with the punch, I could throw a punch at somebody, not intending to cause death or serious bodily injury, but I could throw that punch at them and they could fall down and hit their head on this table. Or they could fall down a flight of stairs, or all kinds of things can happen that transforms it from just like force to deadly force. Okay. But the question for you is when you're looking at the reasonableness, because I think you do have to look at the reasonableness of what he did. Was the knee strike reasonable? Another thing, when you watch that video, take a look at it. Right before he actually drops his knee, you'll see him crouch down a little bit. So he's not dropping from his full height. He actually crouches down a little bit before he goes down. And I think that's important. But again, seen police officers, seen Muay Thai fighters, seen all these people, just like you all have, do these kind of things without having that kind of a result. Let's talk about the injury. You know, I think there's a real legitimate issue in this case about the injury. Was it caused by the knee strike? And again, if you find it was not, then there's no serious bodily injury, then Mr. Rendon is not guilty. And so you'll remember when I was talking with the doctor and we were talking about all these different things that can cause a ruptured intestine. We talked about you know, an infection that causes inflammation or diverticulitis. We talked about peptic ulcers. We talked about blunt force trauma is one of the things that can do it. Penetrating trauma, like a stab wound, is something that could do it. Inflammatory bowel, appendicitis. There's just long-term NSAIDs, bowel obstruction, and one of them is scarring from surgery. And we know from the medical testimony that Pablo Rodriguez had a previous hernia operation. You heard the doctor talk about that, and he talked about how sometimes there can be scar tissue inside the bowel that can, over time, cause a bowel obstruction. So one of the things you need to do is you need to sit down and take a look at that and decide if this knee strike actually did cause that serious bodily injury. You know, one of the things is there's a delay in reporting. Is you saw him walk out of the bar, you know that he went home, and these problems developed later. Is it because they did not occur from the knee strike, or is it because there was just a delayed outset? So you need to sit down and take a look at it. And again, I think that fact that he had this previous hernia surgery and that scarring from a surgery is something that can cause a bowel obstruction, I think is important. We also look at this, is if it's possible that the knee strike caused it, that's not proof beyond a reasonable doubt. The state's burden is very high. We talked about it. They have to prove beyond a reasonable doubt that the knee strike caused that injury. Most likely is not beyond a reasonable doubt. You have to believe beyond a reasonable doubt that the knee strike is what caused the injury. One of the problems with the state's case is we have unreliable witnesses that are basically telling you lies. This is one of the most significant pictures in this case, not because it goes to any element of the offense, but because you heard the testimony of Tina Jimenez and Pablo Rodriguez, that he just walked out of his own accord, that he just got up and walked out. But here we see him being escorted out by Anthony Cochran. Okay. Was it that he was so intoxicated that he doesn't remember being escorted out? In which case he probably lied to you about the number of drinks that he had. Or is it that he's purposely trying to make himself look good and reasonable and in a sense lying to you? Because we know that he got walked out. So it's like somebody brings something and then we bring the receipts. And that's the receipt of that. This tells you that when he told you that and when she told you that was not true.
5 minutes.
Next slide. The same thing with the drinking. We have the same issue. So first of all, let's talk about court and police math when it comes to drinking. Every person that's ever been convicted of DWI, 90% of them told you they had 2 beers and that you can't get to 0.08 on 2 beers.
All right, that'll be overruled.
So every person says they had 2 beers. In this case, he told you he had 5. And so the actual, this is just my joke equation, but it's kind of accurate. Is you take the number of actual drinks you had, you divide that by 3, and that's what you tell the police officer. So I had 6 drinks, I tell the police officer I had 2. If I had 5 drinks, I divide that by 3, and I tell them that it's actually 15, but I tell them it's 5. But the bottom line is you're saying something to sound better than the truth, which is a lie. We talk about all the things, Tina and Pablo both made it seem like you barely had anything to drink. But then when we bring the receipts, we see Officer Casey Wilson said that when he saw them, that they were highly intoxicated and combative. And Pablo, her own statement, she once she heard the tape, because we brought the receipts, she admitted he drank and drank and drank for his birthday. He was a little more drunk than normal. He had too much to drink. But the bottom line is she only admitted to those facts when she knew we had it on tape. That is somebody who's lying to you. That's somebody who's telling you something that's not true. And the video, let's talk about the video real quick. Why is this an edited video? Obviously, we know that the encounter lasted a long time before this occurred. When you see something like this and you start to turn your video on, you hit the play button and you're bringing it up and it's blurry at the beginning because it takes you a second to get oriented when you're not expected to this. I don't believe Esperanza 1 minute that she got this from the internet. Somebody she knew in the bar took this video and gave it to her. And they took the part that was bad for them and they cut it out. And that's why we only see the last few minutes of this fight. The problem is once you have people that are lying to you, you don't know when their lies stop. You don't know when they're not telling you. Once they start telling you lies, you don't know where that stops. And you heard one party that's being honest and truthful in this, but we have two different versions of this event, two totally different versions. You have the version of them. He took one extra drink and he threw it in the trash can. And Anthony Cochran, who is sober, just goes berserk and attacks him. Is that reasonable? That's not reasonable. He's a security guard. He just wants to get the beer in the bucket so that he can go home in an hour or less than an hour, in about 45 minutes. This is going to keep him there a lot longer than that. It's not reasonable. What's more reasonable is a drunk person who paid for a beer who doesn't want to give it up and is willing to fight for it, feels insulted. When we talk about that, we talk about the two different versions, totally different versions. We have one group of people that have told you things that we know are lies and have misrepresented things to you, and we have another party that has not. So you have to choose to believe. And I would tell you that this man and Krista Porter never lied to you. But when they brought their stuff up and we brought the receipts, they failed. This was a terrible police investigation. And that's important because it's hard for you to get the right facts. How long, we talked about it, it takes 3 seconds to identify these witnesses. What's your name? What's your address? Failed to do it. This is a felony case. This man might go to prison for 20 years and they can't take 2 seconds to take the names and addresses of these witnesses and identify them. Witness statements. Every single person that saw that fight should be getting a witness statement, even if it's only a few minutes on the body cam. There's people that never spoke to the police. They didn't even identify them. And what were they doing? They were lying about their names. You heard Esperanza say that she's an admitted liar. She said I gave him a fake name. We have the other guy. His name in the report is completely different than what his real name is. They failed to go look at the videos. They're right there. The only reason they have the videos from inside the club is because we provided it to them. They never asked Tina and Pablo who else was there. Why wouldn't you do that? Hey, you've come to us. You want us to investigate this? Then we're going to sit down. Who was this other person? Let's go get a witness statement from him. They never talked to any of them about the assault. They never confronted. If you're taking a witness statement from somebody, you take what they got to say, but then you take what the other people say and say, hey, wait, they're saying that you assaulted somebody. Let's ask about that. They never did that. It was a biased, not only was it a terrible investigation, it was a biased investigation. There were crimes that they knew about. They knew about the robbery. They knew about the assault, and they never looked into it. They never confronted those people with that. They never confronted Esperanza about her conduct on the video. Look, if she really got the video from some strange person, the state can file a subpoena, get those social media records, find out when that video was transferred and who transferred it for them, and go see if they have the original video that's unedited.
Time.
Failed to do that. Just 1 second, Your Honor.
Okay.
Next slide. Look, they have to prove this case beyond a reasonable doubt. And they have failed to do so because they have failed to disprove that he was not acting in defense of himself, not acting in self-defense of Pablo Rodriguez. And because they did the robbery, you're presumed to find that is accurate. Thank you very much for your time.
Wow. First of all, I've seen a few trials with Judge Boyd. She cuts people off when she says time. Here, she didn't. Now, I only seen like 3 or 4 trials with her, so I can't say this is her MO. But yeah, all the other trials, all three of them, she was dead on. No, you had 20 minutes. Go sit down. But now we have 17 minutes, I believe, of state's rebuttal.
All right, speak. Yes.
I don't care how bad Pablo is, he's a civilian. Ladies and gentlemen, that is unreasonable. And it is not supported by the law, and that is the reason that we are here today. Now, I've already talked to you about the elements of the offense. I'm going to talk to you about the mental state. You are not required to read minds. You can infer this from the facts and circumstances that surround this. You heard testimony from the defendant that he did not bluntly strike Pablo with his knee because he intended to be cruel. But his acts, by definition, were reckless. And we're going to look at the facts and circumstances that surround this and prove that it was reckless. The defendant's desire was to strike Pablo with blunt force with his knee. If you look at State's Exhibit number 2, when Pablo is struck, he is laying, his head to his tailbone is laying flat on that wood dance floor. His left side of his stomach is fully exposed, and the defendant grabs Pablo's left knee and grabs onto Anthony Cochran's back and drops his knee down. We all know that the stomach is a sensitive area that is full of many vital organs, and any blunt force to an area like that that's unprotected can cause a tear, rupture, or fracture of any bodily organ. Now, I want to talk to you all about the defenses. The defendant was not acting in self-defense at all, okay, especially against Pablo. There's been no evidence that he perceived any threat coming from Pablo. What he testified to is that he believed that Esperanza was using force against him and that he used force back against her. But regarding Pablo, you all see the video. The video is the clearest piece of evidence that we have in this case. And Pablo is not threatening the defendant. Now, I want to talk to you all about defense of third person. Regarding the defenses that are in the jury charge, just because you receive them in the charge does not mean that it's the court commenting on whether these are legitimate defenses or not. Okay, the defendant is entitled to it because it was raised by the evidence. And so let's talk about defense of a third person. A defendant is justified only when he reasonably believed, as viewed from his standpoint, that Pablo was using or attempting to use unlawful deadly force against Anthony Cochran, that his intervention was immediately necessary to protect Anthony Cochran, and that his use of deadly force and the degree of deadly force were immediately necessary to protect Anthony Cochran. Well, let's look at the evidence. It is clear that Pablo Rodriguez Salazar was not using or attempting to use any unlawful deadly force against Anthony Cochran. And how do we know that? Well, the witnesses all testified that Pablo didn't use any force at all. When you look at the State's Exhibit number 2, when Pablo's laying on the ground, you can see that he's kicking his feet around a little to free himself from the grip of Anthony Cochran. That is not deadly force. That, at a minimum, would be non-deadly force. And so you cannot respond to that with deadly force. The defense witnesses testified to a tug of war over beer. Okay, that is non-deadly force. You cannot respond against you can respond against unlawful force with regular force. You cannot respond against unlawful force with deadly force, which is sending somebody to the hospital for 50 days. The defendant's intervention was not immediately necessary. And how do we know this? In the State's Exhibit number 2, Anthony Cochran is on top of Pablo the entire time. Pablo, at a minimum, is shifting his weight from side to side. As I explained earlier, Pablo's head to his tailbone is laying flat, stomach fully exposed, and that's when the defendant grabs onto Anthony's back and Pablo's leg and drops his knee down. So he knew at that time, in his standpoint, he knew that Anthony Cochran was on top of Pablo And he knew that Anthony Cochran had control of Pablo at that time. That's what makes his acts unreasonable. His use of deadly force and the degree was unnecessary. The defendant testified that his own staff is not allowed to go hands-on with patrons. That's a rule that he implemented and he violated himself. You heard his testimony. He's not a peace officer. He's not a security guard. So if he has this rule in place for his staff, why is he violating his own rule? He testified, the defendant testified from that stand that the proper next step would have been to go and grab Pablo's legs and neutralize any movement. Okay, that is not what he did. A reasonable belief is a belief that is held by an ordinary and prudent person in the same circumstances. So let's look at that. Let's look at all the other patrons that are in the vicinity of what is going on. They're all standing watching there, including Chris Villanueva, who I would implore was not a credible witness at all. He wouldn't even admit that he was in the state's exhibit number 2 and a photo of him clearly in the entrance exit way of Volcan. You cannot believe anything that he said. You can see that other people, other patrons are walking by. Some people are still dancing. And some people in the crowd are yelling at the defendant. And look at the defendant's demeanor in state's exhibit number 2. He's yelling at people in the crowd that are not even involved. There was no apparent danger, and that is clear because there is no sense of urgency from anyone else in the location but the defendant that's sitting over there. The defendant is the only person who felt that he needed to protect Anthony by assaulting Pablo. If Anthony had a firearm, why does he need to be protected? That was an unreasonable belief. There's no presumption of reasonableness in this case because there's no evidence of a committed robbery. Ladies and gentlemen, you will have the evidence with you, which includes video of Esperanza, Carlos, and Ricardo exiting the location. You don't see the hat, you don't see the baton, and you don't see the radio anywhere. The defense also, the photo that he had with Pablo walking out, you don't see the radio, baton, or hat anywhere. Volcan was packed that night. Anybody could have taken those items. There is no proof that Pablo, Tina, Esperanza, Carlos, or Ricardo took any of those items. And so there was not a robbery on that day. Furthermore, at the time that this occurred, the defendant had no knowledge that these items were missing. He comes in when he says that this whole, using their words, melee is going on. He has no idea that those things are even missing if they were, and they are depicted in the state's exhibit number 2 laying on the ground. But you all need to track the exit of the witnesses, and you can see that they are not in possession of any of those items. You can also look on the officer's body-worn camera. When they're speaking to the officer, they are not in possession of any of those items. And so we have proved beyond a reasonable doubt that no robbery occurred. The evidence supports a finding against the defendant's assertion of self-defense and defense of a third person. Testimony is evidence. We talked about this in jury selection, so we're going to talk about some of the testimony that occurred. You heard from Officer Salas. He testified that he was first on scene at Volcan on August 20th, 2023. He testified that Pablo did make an outcry to him on that night regarding the assault, but he did not make any arrest on that night. When he had an opportunity to view State's Exhibit number 2, he testified that he would have reached a different conclusion had he been in possession of that video on the night. We'll move on to Officer Soto. He testified that he was dispatched to Pablo's home 2 days later on the 22nd to take a report. He took statements from Pablo and Tina. He researched the negligent investigation that Officer Salas did, and knowing that information, he still decided to write up a report and forward it to a follow-up unit for investigation to occur because he determined that an offense had occurred. Detective Gross testified that he conducted many interviews. He collected the video evidence, which corroborated what the witnesses testified to, Pablo, Esperanza, Tina, and Carlos. And the result of his investigation was the use of force was unreasonable. He also conducted an interview with the defendant, who stated that he didn't even touch Pablo at all, and that the internet was down for the cameras, so he was unsure if he would be able to provide the surveillance video. Ladies and gentlemen, if the defendant was in such fear and he felt that his acts were reasonable, why would he say that he didn't touch Pablo at all? Because he knows that his use of deadly force exceeded the scope of the law. Of important note, he fails to mention things that he testified to on the stand, which was that Pablo jolted his head. The first time that we heard of that was last week. That he was in fear for Anthony's life. He's never stated that until last week. That Pablo was reaching for a gun. That has never been uttered until last week when he was on that stand. And that Pablo was cut off from receiving any more alcohol. Never mentioned that to Detective Gross. I want to agree with one thing that the defendant said is that it's easy to Monday morning quarterback when you know that you're facing the jury of your peers and you've had 2 years to concoct a version that is sympathetic to yourself. The only thing that the defendant told Detective Gross is regarding Esperanza. And he said that Esperanza attacked him and that he used force against her. Okay. What is important is that nobody had State's Exhibit number 2 at this point. And so the only reason that he's coming up in here and taking accountability is because we have State's Exhibit number 2. If there wasn't a patron that was recording that night, we would have never known who caused serious bodily injury to Pablo. Tina would have never known that this person that she trusted caused serious bodily injury to her husband. You all heard from Dr. Guns. He testified that Pablo sustained serious bodily injury. You heard that Pablo had to have 2 surgeries. The first was removal of a part of his intestine, and the second was the bowel obstruction that was caused by the first surgery. Okay, not some hernia surgery that happened 9 years ago. And so I want you all to think, is it possible that the hernia surgery is what caused the intestine issue? Maybe, but what does the evidence suggest? Look at the location of the blunt force strike and the temporal location. 2 days later is when he has to go to the hospital. It's unreasonable to believe that he lived with the hernia surgery 9 years, and then just shortly after this is when he's going to have issues from a hernia surgery. That's unreasonable. Pablo, Tina, Esperanza, and Carlos are all consistent with each other and the video evidence. At this time, you are solely determining whether the defendant is guilty or not guilty. Not defenses to this offense, or that the defendant did provide some video that's hazy and we can't even see what's going on, that Pablo was cut off if he was intoxicated, that it was last call, and that Pablo didn't throw his beer away. I want you all to think, what was the rush? The defendant testified that his patrons can continue drinking until 2:15. What was the rush that Pablo had to throw his beer away right then and there? That it would cause Anthony Cochran to grab the beer from Pablo
5
and
minutes.
throw him to the ground. We do have the burden beyond a
That's not
reasonable
what
doubt.
happened.
It is not beyond all doubt, but ladies and gentlemen, that video tells you everything that you need to know. You are not to let bias, prejudice, or sympathy play into any part of your deliberations, and you all do have a duty to deliberate, to consult with each other, and with a view towards reaching a unanimous verdict. And you shouldn't hesitate to re-examine your views and change your opinion if they are unreasonable. You all swore to render a true verdict according to the law and the evidence. Ladies and gentlemen, there is only one verdict in this case, and that is finding the defendant guilty of aggravated assault causing serious bodily injury. We cannot hold a substandard law enforcement investigation against Pablo, okay? Tina had to fight for Pablo to receive an investigation that would bring us here today. You need to hear them, let them know that you hear them, that you believe them, and find him guilty. Thank you.
Yeah,
All right.
yeah. When she said took the beer from him and threw him to the ground, that's not really what happened. That's strange. That's like the base fact in this case.
All right, is there anyone who's ready to proceed? Just have the clerk pull your file and I'll take your matter.
Okay, folks, that jury left the building. We are now at verdict watch. And at verdict watch, we are going to check Judge Boyd doing her docket. I don't think the jury will take a long time either way they decide.
All right.
Judge,
Yes,
can I approach?
yes.
Apparently my client showed up.
Okay, and who's your client?
Ms. Hernandez Mejia, please stand up for the court.
All righty. All right.
Thank you, Judge.
You're welcome. David Warren Brown. Could I see the file on David Warren Brown, please?
I think there was only one that wasn't admitted.
Well, no. These reports,
Okay, as soon as you come out, let me know, and then I'll put them up.
I think it's two. Well, no, it's three, because it's state exhibit number 22.
Victoria? That has helped greatly.
Francis gave it to me.
Oh, yeah, I'm like, wow. So, yeah, thank you very much.
Yeah.
And you know what, I smell it, even though I have
We
opened it,
are
I
at
still get the
verdict
scent.
watch.
Well, 22 is not in here.
And we are checking
Oh,
out
it is awesome.
Judge Boyd's
Because he didn't.
And I'll make sure you get it back.
morning
Yeah, that
docket.
one's not.
All right, thank you.
I smelled it on the third floor,
Oh, so none of these
Thank
came.
you.
but I didn't smell it in here, but I did smell it on the third.
See, I'm like Gus from Psych. I can smell it.
Yes, and it is.
Oh,
I need to get myself some coffee. I'll be right back.
That's number one. I keep thinking that's a number two.
it's for my mom.
1, 15, 19, and 22 are not admitted. So then all this can go by.
Yeah, I put number 22 is one of them. Okay.
Victoria, make sure I get this for my mom as well.
Yes, it's worth it. One drop is enough.
Ah.
He's already, he's been in line for that.
All right, thank you. And have they conferred over the exhibits and they agree?
Well, I don't know where Mr. Bloomquist is.
Jason, can you look at the exhibits and make sure that those are all the exhibits? Oh, okay.
It's not here.
Okay. Yes. Oh, they're here? Destiny Blair? Destiny Blair? Can we call them? Because I haven't seen them yet.
I took some lemonade instead of coffee.
If he could move in one, because I gotta talk to him. Thank you very much.
Yes. 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 All right, thank you. I'll give you a call before I'm there.
Apparently, in the Karen Reed trial, Yuri Buchanan,
If you'll, grab the phone.
sorry, Yuri Buchanan has claimed in court that all the things that Trooper Proctor said in that group text with his colleagues is Proctor's First Amendment rights. Yuri Bukaki is. I'm just looking at X, what people are writing. I will check that out later. But it seems like Yuri Buchanan single-handedly is throwing the state's case against Karen Reed. And apparently, Hank Brennan, prosecutor, has filed a motion for a voir dire against Yuri Bukaki because he is trying to have Yuri not testify about a lot of things. Oh, it is a clusterfuck.
Sorry, Judge.
Oh, we did. You know, she always with continuance and it'll be fine. All right. On this,
Thank you.
you're welcome.
I've
So,
already conferred with defense counsel and he informed me of what. he
Hey, thank you, Jude.
all right.
Thank you
So,
so much
when
for
are you
all the
asking it to be
super chat.
recalled?
That is, I appreciate it very, very much.
Okay. All right. Oh, yes. Miss Ferguson, could I have a 30-day reset?
Yes, ma'am. Give me 1 second, Judge.
Hey, we try.
June 10th, Judge.
All right. Well, you know what, of course, my mom always says that other than being at home, where's the most time you spend your place at work? And so the cases we deal with on a daily basis, if you're having a hard day, hopefully you see the flowers and it makes you smile. And then you can say, you know, life is beautiful, you know? Oh, we did. You know, she always says, this is the best Mother's Day, or this is the best Christmas, this is the best birthday. So I wasn't there for Mother's Day, but I always go for her birthday. It's April 22nd. So it's sort of
Excuse me.
an overlap. Yeah.
Could you keep this for defense
Yeah.
counsel?
And
Should be.
usually when I leave, I'll put a card underneath her pillow. So when I leave and I'm on my way back, and then when she finally goes to bed, she'll call me. All right, so we're gonna have you come back on June 10th, okay? All right, thanks for dressing appropriately for court. If you'll have a seat, once your attorney brings you the reset form and you sign it, then it'll be done. All right, and so what I can tell you is I'm looking at the allegations in your motion. I don't take any of it as true, but you better stop, all right? All right, thank you. Oh, you're welcome. Okay. It's June 10th. So we have to go. Okay. So we're.
Yes.
Is it, off docket? Okay, she has to pick up matters until the applicant is 1:30. If we start here. All right, thank you.
Just give me a moment.
Yeah. Yeah. All right. You are.
Jenna? Yes. Do you have a file on Marisol Vasquez? And counsel, you're here for,
Monica Wade, you're on the MTR.
you need to have them pull the file.
Okay, the state, I just wanted to let you, the state was gonna be withdrawing the MTR.
All right, once they, just have them pull the file and I'll take it up.
Okay.
Yes, if you're lurking, please pop in and say hi. An active chat
Here it
makes
is.
the
Sorry about
algo,
that.
and hit the thumbs up, and yeah, you know all the YouTube things. Thank you.
No, because they're withdrawing.
Oh,
So I just need that.
All right, David Warren Brown. All right, who's here on Sergio Garcia?
That's me, Judge, and we are ready.
All right,
Go ahead,
Mr. Garcia.
It was going to be a contested MTR, but the state is going to withdraw the MTR.
And state, what's the reason for withdrawing?
Come to a proposed agreement, Your Honor, on the term of the MTR. Well, this is just my notes.
I don't have the withdrawal sheet.
Okay.
I'm sorry, I wasn't on the quite yet.
All right.
Sorry.
Yeah. So how's it going?
It's going. How are you?
All right. So have you already went on your trip or is it coming up?
It's coming up. So we went on a CLE about phones, which was very interesting. All about phones and the metadata and the dumps. And so that was very interesting.
Tell them to get that for discovery quickly. How can you receive it quicker than what they're doing?
Yeah. But then we're going to go to Mississippi in January.
Oh, what do you got? Which part of Mississippi?
We're going to go to Biloxi. We gamble.
Oh, well, good luck.
I call her.
Yeah.
She's putting it up now for you.
All right. Thank you.
I'll sign it.
All right. So what's the reason for the withdrawal?
So Ms. Jones called me on Friday. We had previously set this for a contested, I guess, after some further investigation. We reached an agreement that they would withdraw the MTR. We would alter and amend, put it for IOP and a no contact order. That was more suitable with the evidence that they had. All right.
Probation. On this case, do you need an updated TAP evaluation?
Yes, Judge.
All right. Yes. All right, so Ms. Christian,
Yes.
based upon what I'm reviewing and the motion to revoke, I do have concerns with the drug use.
Okay. You need to talk to us?
So the TAP evaluation is going to be in custody.
Okay.
My understanding that should be relatively quick.
Alfredo Campos.
So I'm gonna auction them in a TAP evaluation, follow TAP results, because I don't know if they're gonna
Recommend anything
yes.
or something?
And then, Ms. Abrams, I'm gonna ask for 120 sober meetings and 120 days upon release. So that'll be a TAP evaluation in custody. Follow TAP results. Plus 120 sober meetings in 120 days. Is there anything else you need from the court to be successful?
I just don't know why I didn't pass it anyway, that's at that time, I was taking medicine for a broken tumor.
Mhm.
And I did go to a meat market to get antibiotics, my face was sore.
So here's the thing, when you're on probation, and this is what I tell everybody, everyone, please whisper. Your life is not your own, right? So anytime you take any type of medications, you need to make sure that a prescription is given to probation. So when they test you, they can see whether or not that medication will cause any type of false positives. And here's the other thing. I don't know what's going on between you and the complainant that's listed. Sure.
I have no idea who that's. I've never heard that before.
Well, that's good for you. So you don't need to be around that complainant, okay? So what you're on probation for, if your probation were revoked, and I'm sure your counsel has told you this, you're looking at life in prison. So don't step wrong.
Oh,
I'm not doing that. I mean, I've got my
Oh.
driver's license, I got a vehicle, and the only way I found out about. the
Jesus.
warrant was
Yeah.
I actually got pulled over and officer was gonna let me go with the warrant.
But then
But then
it's,
he thought that I had a warrant, so I was surprised, just surprised as anything.
okay. All
I
right.
just. Just now scared out there.
Okay.
I'm walking on thin ice, so I walked every step I did.
All right. So here's the thing, if anything goes wrong and you feel like you have some issues with anything, all you have to do is, in this court, all you have to do is let your probation officer know.
Yeah, I understand.
And if that doesn't happen, you can come in here and let me know, okay? You wanted to address something?
Yes, Judge, I just wanted to confirm that, you wanted the no contact also in the limited condition.
Yes, and yes, no contact with the complainant.
Thank you, Judge. And if I could get my withdrawal form.
Yes, you can. Let me see where I put it. Paper is being, here we are. You know, when you have so much on your desk, paper starts disappearing.
Like that sock in the dryer.
Oh, yeah, it's like, what do you call it? What do they say when things disappear? Who's doing it? The fairies or something? Yes. Okay, let's not bring tummy knockers up in here. That's very scary. All right. All right, thank you so much. I love your pen.
Thank you, Judge. Will we be excused?
Yes.
Okay.
Oh, and Ms. Christian, if for some reason you believe the TAP evaluation is taking too long in custody, you can come back.
I'll let you know, Judge.
All right, thank you.
I need it.
Okay,
That's actually better than I thought.
all right.
Education is up there.
You got one? Why?
Because we don't have carbon copies. You know, how you have to give a carbon copy.
Yeah. Okay, and the other thing is up there.
Yes. No. He's in top. The old man way on top of the glass. Oh, she's the older. Oh, I'm sure. Garcia.
Yes.
Move over.
David Brown. Ms. Ferguson, if you can see where his attorney is. And did you check on the person who's being sworn in?
No, not yet, sir. I just had a, I was talking to me about a situation. Oh, yeah, well, I think I came in. She goes.
Yeah, still waiting for verdict. Been waiting for roughly 20 minutes. So that's it would take a jury at least 30 minutes to vote and sign all the documents.
Destiny Blair? Thank you.
Yeah, on interpreters here. No, it's first appearance on indictment. The family violence.
Getting sworn in. Thank you. This is the only person. I'm just gonna leave it for the one. Thank you.
Hey, Woody. Can you trade places? It's a funny. You guys have
Raul Lopez?
Ready, Honor. We have an interpreter.
All right. Hello. Hi. So, Mr. Lopez, is your client a US citizen or no?
He is not a citizen, Your Honor.
Do you have an immigration attorney?
Oh, we're gonna request one from the MAC.
All right. So where are we on discovery?
Almost gathered all evidence except defendants was submitted to a stain exam that has been submitted to the lab. I need to check with the lab to see if they have finished testing that and provide the results of that to defense, along with confirming victims' interview at Child Safe and making that available for defense to review.
All right. And was there any CPS records?
Yes, there were, and those are available. I don't know if defense has those or not, but if he doesn't, we can provide. I can make a copy. I don't have them right now, but I can make one and have one ready for her.
All right. And do you need me to sign a protective order?
I will print one up for you, yes, Your Honor.
Norma? recall this case for. I'm going to recall you for July 28th. And that will give your attorney chance to speak to immigration. And
Thank you,
that will
Judge.
give the state, if there's any type of DNA evidence, the chance to at least have that available. Do you
Thank you,
have
Judge.
any? You're welcome. Do you have any questions?
No, it's okay.
All right.
Thank you, Judge.
All right, thank you. Yes.
I need your.
Sure, hi.
Nice to meet you.
Nice to meet you. And what's your name?
Have a again.
All right, good meeting you.
Yeah.
Thank you.
Thank you.
Thank you. July 28th.
I'm still on hold. Judge.
All right.
Yeah. She was asking about Brown, being Brown.
Ready on Mr. Hugh.
Who's Brown up there? David Brown?
He's up here.
Oh, Donavina's here.
All right. All right, and counsel, your client has not shown. Brown,
Yes, Your Honor.
your client hasn't shown. So have you had any contact with him? All right, could I have someone from the state for a non-appearance, please?
Is this a commercial bond or personal bond, Judge?
Let me look it up, just 1 second. Obviously, it's moving slow. Either way, counsel, I'm inclined to issue a judge's warrant, just in case, because sometimes people are not getting notice. I'm unsure if that's happening in your case, since you said you had no contact with your client. So with the judge's warrant, it will be easier to recall that, as opposed to issuing a bond forfeiture. But let me see what is in here. The little circle is going round and round. How have you been doing?
Chair, because probation you can talk to. The update your information. No, just go say, excuse me, excuse me.
Yeah, it's a commercial one. All right, court is calling 2025 CR 0034882, State versus David Warren Brown. Could I have parties announced for the record for the state?
Andrew Harris, Edelman.
Valentina
Defense.
Kogut on behalf of David Brown.
All right, this hearing was scheduled at 9 a.m. It is now 11:32 a.m. Court called the docket. The defendant did not answer. Deputy Laura, did you make an announcement?
Yes, Your Honor, nobody's out there.
All right, state.
Forfeit the bond, issue a warrant.
All right, and defense, have you had any contact with your client?
No, Your Honor.
The court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you.
She
Yes.
rarely reconsiders.
Great, thank you.
I'll drop by tomorrow.
Okay. Thank you, Your Honor.
You're welcome.
Thank you.
And that's a judge's warrant, Jenna.
No, I don't know. Oh.
No, okay, no.
I'll be back in 5 to 10.
Serious couples.
If it helps any, like, she's been like putting in my books and visiting me. Can I get approved, for calling them stuff? Like she puts money in my books every week.
This is like to be a violation of no contact. They can charge you to say that. So be careful about that. And don't talk about the cases of anybody else, like any family members or stuff. Only what you tell me is confidential privilege. They can't use that against you, but anybody else, they can try to use that. So they listen to the judge all the time. So be careful. Thank you.
Monica Wade. Oh, yes. What are we here for?
Motion to withdraw a motion to enter adjudication of guilt. The state cannot produce the witnesses that we need to substantiate the violation allegations.
All right,
As
so,
I understand it, there is only one violation allegation.
yes. All right, and who are the complainants alleged to be in this case?
The complainants, if I remember correctly, is Richard Slackner, SLAGTER.
SLAG.
TER.
All right, you're not to have any contact with this person, do you understand?
Yes.
You are on
Let's see what he.
probation,
Oh, no, you'll find this.
and what you're looking at is potentially 5 years in the prison, do you understand? All right, the court is going to sign the motion to withdraw. And there's to be no contact. Ms. Abrams, there's to be no contact with the complainant, Richard, SLAGTER.
GTER.
And if you can give that to Ms. Abrams. Is there anything else? All
No, Your Honor.
right, thank you for dressing appropriately for court.
Your Honor, does it require a court order to take off the GPS as condition of bond? They'll automatically do it.
If they should do it. But if you need an order, just let the court know.
Okay.
Who's here on Alfredo Compass? Okay, so. All right. On this case, where are we on discovery?
Go ahead.
I conferred with the state judge with regard to discovery. I believe there may be some outstanding videos. So I requested the state so they can make efforts. You missing?
Yes, I will look into the videos, Your Honor, and provide those to defense if they're able to be found.
All right. I need a 30-day reset for discovery, please.
Yes, June 10th.
All right, so we'll have you brought back on June 10th. All right, thank you.
Have a seat there. Is that for discovery?
Yes.
Thank you.
Who's here on Mario Whitty?
Mr. Whitty?
Morning. Yes.
Your Honor.
Yes.
This will also be a motion to withdraw the MCR. I reviewed the file provided to me by Supervision Officer Simonelli. The defendant has a successful affirmative defense for due diligence for the condition. and
I
violation
imagine so,
allegation.
because this is from 1999.
Yes, Judge.
Isn't it Prince? We're gonna party like it's 1999. This is during that time frame. All right. The court will sign the motion to withdraw.
Judge, I need direction on if the termination will be unsat or sat.
Well, has he successfully completed it? If he hasn't successfully completed it, then it'd be terminated unsatisfactorily. If he successfully completed, then it'd be terminated satisfactorily.
If I remember correctly, he had not completed his supervision hours.
All right.
Judge, there are no program or classes or community service hours listed. There is a remaining balance on the account.
But he did have a financial means to pay it, so.
All right, so y'all have to present evidence of that, because I don't have any evidence of that. So it's gonna be term unsat. All right, thank you. Good luck to you.
Thank you, Judge.
You're welcome.
Case number?
Yeah, compost. Laura.
I have two, please. This morning.
He's gotta go to 15.
15, okay, next door.
Who is here on Miguel Velez Jr.? So on this case, where are we on discovery?
I believe I have it all, Judge. We are resetting for possibly a dismissal. There's some things they need. So we just need about 30 days for my client to be able to collect the proof I need to give them, and then we should be able to resolve this case.
All right, Ms. Ferguson, I need a 30-day reset for disposition, and that will be your plea deadline date as well. All right, June
Perfect.
9th.
Yes,
Once you
June 9th.
sign the reset form, you are excused. Thank you for dressing appropriately for court.
Thank you, Judge.
You have a good day.
You too.
It's growing, but it's so long. But I'm amazing.
Who is here on Amanda Drummond? All right, Ms. Drummond, you'll come down. So they're recommending for you that you go to safety because you didn't qualify for felony drug court. So, and you were medically disqualified for DVRF.
Okay, if I might speak for that.
Yes.
The drug court refusal was because she had a warrant in Wilson County.
Okay.
That had since been cleared, so she would qualify for drug court.
So what I'll do then is I'll alter them in conditions. If y'all will refer her then back to felony drug court. And
In
yes.
addition, she's been taking drug treatment while she's been at the jail.
Awesome.
They've already given you time. So you,
She's finished that doing well, and they have her on a maintenance program, so if she uses, she gets sick, so that's a pretty good incentive.
All right.
So we refer to
Yes.
felony drug court.
Since she lives in Karnes County, would it be possible to be treated to?
If she lives in Karnes County, they're not gonna accept her in felony drug court.
There
Right.
was,
So I was wondering if we could, since she's been getting treatment and continuing on a maintenance program. Her job down in Karnes County she's been working for a firm that fails hay. That season's about to start again, and they've held her job open. But they won't be able to continue holding her. Now, she doesn't have a job, she can't afford to pay probation anyway.
Well, no, she's either gonna go to safety or go to felony drug court, and if she's out of county, felony drug court won't accept her here in Bear County. If you want to check and see if there's a felony drug court in Karnes County, I don't know if there is. And see if they will place her in the program there.
Okay.
Judge, I believe we spoke about this the last time she was here, before she was referred to felony drug court the first time. And she indicated that she did have somewhere where she could stay here, which was at her mom's address in Bear County.
Oh, all right. So then we'll do a referral to felony drug court.
Okay.
All right.
And if not accepted, do we move forward with the safety?
We'll come back and I'll see.
Okay.
If that's still a recommendation from probation.
Okay.
Okay. All right. So, Ms. Drummond, what's going to end up happening is you're going to be referred to felony drug court. If for some reason that doesn't work out, we'll bring you back and we'll figure out something. It's okay. All right. Thank you.
Thank you.
You're welcome.
Yeah, still waiting for a verdict.
All right. Who's here on one cruise? All right, we're here for discovery. And you've received the CPS records?
I have, yes.
All right, is there any other outstanding discovery?
Yes, I made that request.
All right, what is outstanding?
So I am needing phone evidence, home surveillance evidence that the CW have handed over to law enforcement. That is not in any of the discovery.
All right, do you have the surveillance?
We were working on getting on that, and as soon as we can, we will provide that to Ms.
I also made a request for counseling records.
Okay. So we need home surveillance and the complaining witness has that?
Your Honor, I was just alerted that these exist from defense's knowledge. At this time, I haven't confirmed their existence, nor have I confirmed the existence of the counseling records. Defense counsel sent us a request asking for these items, so as soon as we confirm their existence.
All right, and the phone records that you're saying, whose phone records?
So it would be home surveillance that was on the phone of the victim's mother, and she had turned that into law enforcement upon my review of the evidence, but I do not have that in any of my e-discovery. The same can be said for a prospective witness who offered that too. I don't have any of it.
All right. And then the other thing you said, medical records or?
No. Within the medical records, there was reference to counseling that was to begin on December 19th of last year. These medical records were from October of last year, so we're needing to see if there was counseling and there are records of that.
All right. So let me see here. I'm going to give you all a little extra time so that you can obtain this. I know how it is sometimes with third parties who have video and you actually don't have them and it's a layperson.
Yes.
We'll recall this. Are you available for July 21st?
Yes.
All right. So we'll recall this for July 21st. Is there anything else?
Nothing further.
All right. Thank you.
Thank you, Judge.
Thank you. Who's here on Jamal Fisher? And are you all ready to proceed?
We are, Judge.
Court is calling 2024 CR 011671 State versus Jamal Ricardo Fisher. Can I have parties announced?
Ashley Jones for the state.
Megan Enriquez for Jamal Fisher.
And are you Mr. Fisher? To review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, did you understand it? Are you the same Jamal Ricardo Fisher who was placed on deferred adjudication in 2024 CR 011671 for the offense of injury to a child, elderly, or disabled person with intentional bodily injury on January 27, 2025 for a period of 4 years? Is that you? Yeah. All right, state.
Yes, Your Honor. The state is going to proceed on violation of condition number 4. On or about the 28th day of February 2025 in Bexar County, Texas, the defendant, Jamal Ricardo Fisher, did then and there fail to conduct himself in a proper and orderly manner during an inmate video conference meeting with the Bexar County Community Supervision and Corrections Department Supervision Officer in violation of condition number 4.
How do you plead to that? True or not true?
And the state will waive the remaining violation.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there proposed agreement?
There is not, Your Honor.
All right. State, what are you requesting?
Your Honor, at this time, the recommendation from probation is amend for DDRF. I do believe that the defendant has undergone a mental health and a substance abuse evaluation, both recommended DDRF, and at that time, that is the state's recommendation as well.
All right, thanks.
Yes, Your Honor, and that was the basis for his outburst with the probation officer. He does deny some of the things that he's alleged to have said, but he does ultimately agree that he did use profanity that was inappropriate. That's why he did decide to plead true. I believe what happened is that at the very beginning, when he pled for deferred, he was misinformed. He believed that he would be getting out. He says he signed for probation because he thought he would get out that day or the next day, but instead he was held in custody. Explained that that's routine and normal and that happens all the time. And so he waited in custody for 3 different evaluations. I believe the TAP, the mental health evaluation, and what was the other evaluation? Okay. Oh, a drug court evaluation. And so he waited in custody for those, and ultimately the mental health evaluation recommended DDRF. So when the probation officer came to meet with him, he says that the video wasn't on, he could hear him, and he was explaining to him that there were going to be new conditions, but he didn't have new conditions in front of him. He, in his mind, didn't feel that DDRF was appropriate for him. He says he doesn't have a drug problem, and since it's dual diagnosis, he doesn't believe his issue is drugs and that he's not a drug user, and that he was just trying to explain that to his probation officer, albeit with profanities, because he was upset that the probation officer explained to him that there was a long wait, and that upset him. And so that was what got us here today, was that interaction with the probation officer. But leading up to that, He was further upset and he wants to explain it to you in his words as well, but this is kind of a synopsis of what he's told me.
Well, let me explain something, sir. I go over conditions with people in great detail. I go over conditions of probation with people in great detail. And I always ask people if they understand what they're being ordered to do. And if they don't understand, I explain it to them. So what I can tell you, when I place you on probation, what I said was a $1,500 fine probated, 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, 100 hours of community service restitution. That was to be waived once he completed anger management, affirmative finding of family violence, no contact with the complainant, and Madam Circle, which was an address, referral to felony drug court for their dual diagnosis program, a mixed evaluation, and DDRF. That's what I ordered. And so what I said was, we're going to try felony drug court with their dual diagnosis because it doesn't take them as long as DDRF. But the court did order you to go to DDRF or at least be evaluated for DDRF if felony drug court doesn't accept you. And the reason why I ordered that was based upon the evidence that was presented to the court on the day of sentencing, that there are some mental health issues. Now, if I send you out into the world and I do not give you help from your mental health issues, you know what's going to end up happening? You're going to end up back here and you're going to say, well, Judge, your attorney will say, Judge, he needed mental health treatment and you didn't even try to give it to them. That would be my fault. That's on me, right? But when I give you things that you need to be successful on probation, you have to sign for those. And let me explain to you, everybody has a right to their feelings, to be angry, to be upset. But at the end of the day, guess what? Everybody's just trying to do their job and they're hoping that they will have a nice day at work. Some people, it's like, gosh, I was supposed to be retired, or I really didn't want to do this as my career. Now I got to suck it up and just continue to do it. And I really don't like it. It's not my passion. Some people, I was only supposed to be here for 1 year. Then I was going to trade school or going to college and do something else with my life. So everybody is just trying to have a pleasant day. And if everyone would treat everybody with kindness, it would really go a long way because everybody's just trying to do their job. Amen. So what I'm telling you is I have ordered DDRF. You're going to have to sign for DDRF. If you don't want to sign for DDRF, then what I will do, I will revoke you and I will sentence you to 3 years in the prison. So you have two choices. And these are the only choices you have. Don't come to me with a third choice. Two choices, sign for DDRF or 3 years.
Can I just share? Ma'am, I never once had an issue with DDRF, and I know what you recommended. I never saw DDRF, as I was explaining to my lawyer. When my probation officer met with me on that Zoom call on the 28th, that was the first time I'd ever got actually a chance to meet him. I tried calling him, my mom and dad had tried calling him, my previous attorney tried calling him just to say hi. I'd never even heard of it.
But you know what the appropriate response is?
Name.
If somebody wants you to sign a contract, at least in this realm, in the 187, you need to say, well, I'm confused, sir, because I don't believe the judge ordered DDRF for me. I would like to go back to court. And then that would have been the end of it. Everybody would have been like, okay, and you would have came to court and you know what I would have done? I would have said, Mr. Fisher, I ordered first felony drug court because it's a short wait time. And then if not accepted by felony drug court, DDRF. And then that would have been done. I always tell people, don't get upset because things are not going your way. If you are confused about something in this court, you can always come back to the court and say, Judge, they want me to sign up for DDRF. It's my understanding I'm not supposed to sign up for DDRF.
Ma'am, that my problem wasn't with the recommendation. And if he had said that, I would have been like, okay, well, this is my thing. You gave me, I thought it was a blessing, still think it's a blessing to be on probation. I don't care, DDRF, whatever it is. If you're asking me that, you're the judge, so I'm not going to say no. When the probation officer, all he said, his exact words, I was like, she wants to go to DRF, and I didn't know if he meant to say she was talking you or someone from the evaluations. All I asked was, what's DRF? And his exact words were, you're going to have to wait a minimum 6 to 8 months to get a bed, and then it's a form report. That's when I lost my cool. Then even after that, he didn't say these are conditions of your probation or explain what DDRF was. I was never upset about the recommendation. I didn't even know DDRF was a thing. The only reason I reacted the way I did was he said, you're gonna have to wait 6 to 8 months for bed. And I didn't know what that was for. I'm not gonna say no.
So here's the thing. So if you want DDRF as opposed to the prison term, all right. So I'm gonna deny the motion, alternate main conditions for DDRF. Council, what I'll do is, Ms. Ferguson, I need a phantom date for a setting of 60 days. We'll come back in 60 days to see where he is in the process. Okay. All right, Ms. Ferguson, 60 days, phantom date. All right, so we'll be back in July 10th. July 10th, it's not going to appear in the system because if we have it in the system and they're ready to transfer to DDRF, they won't, and you'll lose your place. Okay. So it's just a phantom date, but everybody here knows July 10th. Okay. All right, probation, is there anything else he needs? All right,
Just to
thank
be
you.
clear, Judge, so that he's admonished here on the record. So today he will have to sign his new conditions agreeing to go to DDRF and he'll be placed on the wait list as of today.
Yes.
No.
No?
The wait list doesn't start today, Judge. You still have to go through an evaluation.
All right, so you still have to do a medical evaluation and everything of that nature, okay? All right, thank you.
Thank you.
Thank you, Judge.
You're welcome. You're welcome. Thank you.
Okay, perfect. Thank you.
All right, who is here on Alexandra Hernandez Mejia?
Ready, Your Honor.
And after that, it will be Veronica Wicks. And then the court is going to take its recess. Court is calling 2025 CR 003-593 State versus Alexandra Hernandez Mejia. Could I have parties announced?
Jason Gear here for the state, Your Honor.
James Seeloff for the defense.
And are you Hernandez Mejia? All right, did counsel, have you received all of the discovery?
Yes, I have, and I downloaded it already and viewed it with her.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count 1 and proceeding on count 2 alone.
Any objection?
That's our understanding and no objection.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand in count 2, your charge of possession of a controlled substance, penalty group 1, 4 to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she does.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on count 2. There's a $2,000 fine. State recommends deferred adjudication, and there's to be restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes.
Defense?
Yes, that's our understanding. We don't agree with the latter part,
What's the latter part?
the non-agreed part. Huh?
Below the line.
Below the line.
Okay, all
Okay,
right.
I'm sorry.
That's okay. State,
It is, Your Honor.
did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There has not been.
Outside the agreement, the state is recommending that you defer adjudication be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, and no contact with Stephan, Stethan Palacios Cruz. Did you understand those are recommendations from the state? And the court does not have to follow those recommendations.
Yes. He is the father of your child, so we do.
All right, so here's the thing. What I'm telling you is, do you understand that those are recommendations from the state? Do you understand the court does not have to follow those recommendations? Then to the offenses charged in count 2, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, we're ready for sentencing. There's no reason not to.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. As far as the gentleman that no contact with, and I told the prosecutor at the end, he is the father of their child.
Mhm.
So there has to be contact. This is a situation where they were trying to, I guess, do a business that didn't work out too well. She does have a marijuana problem, not a cocaine problem, but she does have a marijuana problem. She's been smoking since 16. No cocaine though. That was for sale. I'd like the court to take into account and ask for 4 years instead of 5 years, lower the community service and probate the fine because she's court appointed and she has she's a single mom. She has no money coming in from the father, I guess, on a permanent basis for child support. And so I asked the court's consideration in those matters.
All right, how old are you? Where's your child? All right, and how old is she? All right, so basically the grandparents are taking care of the child. No, but do you and the father take care of her?
Yes.
All right, so how are you all taking care of a child when you're using marijuana and you all have all this cocaine in the vehicle and a gun? So I'm telling you right now, if your child were in that car, ended up using the gun, accidentally killing themselves or killing somebody else, you would be boo-hooing, asking for a GoFundMe page for a funeral. And then you're using cocaine, and then you can't stop using marijuana. If you're drug tested today, what are the results going to be? All right. How often are you using marijuana? All right. So here's the thing. I'm going to grant your application for probation. I'm trying to discover what conditions to place for you. So how often are you using marijuana?
It's slow down a lot. I work, so.
And what do you do for work? That's the new West telemarketing.
They do it at home, she says. I've never heard of that, but maybe that's why they get so many hangups on my phone.
All right. And how far did you go in school?
When I was
All right. What are you planning on doing with the rest of your life? What's your dream job?
I always wanted to work in the office, like receptionist.
All right. Well, what I can tell you is I'm not going to allow you to have contact with Stefan Palacios Cruz. It appears to the court that the grandparents are taking care of the child anyway. And on it,
She just reached out.
when you all are riding around with drugs, marijuana, and guns in a vehicle, where was she? With his mother. So basically, you have grandparents who are being parents, and I'm sure they are just devastated with worry whenever your child is along with you two, because you all are doing crazy things and you both have a drug issue and then trying to sell cocaine. Not going to happen in this court. Is Child Protective Services involved? I don't know why they are not, but that's not my call. I can't pick up the phone and call them and tell them, hey, look at these people here who need Child Protective Services in their life. All right, this is what the court is going to do. There's a $2,000 fine that will be probated. 6 years deferred adjudication. If she completes everything early, I'll consider early termination.
She's gone a little bit more than the state asked for, but you can get off early if you do everything.
There should be regular reporting by Zoom or in person. There should be regular random UAs, tests for levels, do a referral to felony drug court, and a TAP evaluation out of custody. There's to be no unsupervised contact with minors.
With who?
With minors. So you're not to have unsupervised contact with your child until you test negative.
That means your mother has to be present while you have the child.
I just.
Okay.
See, as I said, the grandparents are taking care of the child. I don't know what's happening with this generation. There's going to be field visits 1 time per month until further notice. There's going to be 200 hours of community service restitution. 100 hours will be waived upon completion of parenting classes. The other 100 hours will be waived. I'm requiring parenting classes, but the other 100 hours will be waived if you obtain some type of trade school certificate or complete some higher level of education. There's to be no contact with Stefan, STEPHAN, Palacios Cruz. There's to be 120 sober meetings in 120 days. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors, and to follow all TAP evaluation recommendations. There's to be restitution to SAPD for drug testing. Probation, is there anything else? Yes. And then before she has the unsupervised contact, come back to the court to remove that.
Would you consider your contact order at that time also, or?
But with regards to the defendant,
Different?
no.
That's the father of the child. I don't know.
Yeah, that relationship is not working out for you, and maybe it's working out for you, it's not working out for your child.
You understand? Do you have any questions for the judge?
And basically, it appears to the court that the grandparents are raising this child anyway. You all are just fly-by-night people who happen to produce the child. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. I'm going to tell you what I would always tell my clients on the family law side. Where you are today, hopefully is not where you're going to be at the end of everything. Everybody hopefully is working on improving themselves. Do you understand? So you need to work on improving yourself for you and for your child. If your goal is, you know what, I love this Stephen guy, I'm going to ride or die with him, then you need to excuse yourself from your child's life. Write her a little letter explaining to her when she's 18 that you chose this man over her and that you're just going to be the fun person who comes in once in a while and gives them a gift. But don't keep breaking their heart by doing the wrong things. Do you understand? All right, good luck to you.
Thank you, Judge. May I be excused?
Yes. All right, this is the last case before we take our recess. Veronica Wicks.
Ready, Your Honor. Your Honor, I have a meeting. Do I come back at 1:30?
Yes.
Okay, I'll tell my client.
Sure.
And I'll come back at 1:30.
All right, thank you.
Thank you.
All right. Hi. Court is calling 2025 CR 003243 State versus Veronica Wicks. Am I pronouncing your name correctly?
Yes.
All right, could I have parties announced for the record? State,
Andrew Harris Edelman.
defense,
Fernando Ramos for the defendant.
and are you Ms. Wicks? Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Is there an application in this case?
There is, Judge.
I don't have an application. Did y'all file an application?
We did, Your Honor.
I have it.
Okay.
All right. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1 to 4 grams? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand, counsel? Did you understand that if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yeah, John.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Wicks, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state recommends deferred adjudication. They will take in consideration NIMAG number 761063. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
None.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offers exhibit 1 and attachments.
No objection, Your Honor.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Good, we waive our right to have a PSI and ask to be sentenced today.
All right, anything you wish to say on behalf of your client?
Judge, my client was born in Arizona, lived in Bear County for the last 9 years or more. Is employed in landscaping, that he and her husband. Has no children and hopes that he will grant this application.
All right, is that true? You have no children? All right, what are the ages of your children that you do have? I'm sorry? I know you're saying you don't have any of them with you, but what are the ages? So you have a total of 2 children? Who are they with? So have they been adopted? All right. And what is the writing on your face? Okay, and who is Victor Castillo to you? All right. And does he have any children? And what are their ages? Okay. And other than this landscaping business, do you have any other employment or means of support? All right, so you're gonna have to get employment. Is there a reason why you're not working? I'm sorry, what? Okay, I am so sorry. My allergies are acting up. Would you repeat that again? All right, are you a citizen? All right, so why are you getting paid under the table? All right, so here's the thing. I know that sometimes people do this under the table thing, but that's going to catch up to you. All right, so you're going to have to get your ID and whatever else you need so that you can stop being paid under the table. Because when people are paying you under table, who knows? Maybe they're not paying you what your value is to the company, because they can do that because you don't have any ID. And their whole thing is, who you're going to tell? You're committing an offense by accepting payment under the table. You understand? And you live with this Victor Castillo? Who all lives in the household?
In my house, and then his boss and his wife and his kids live in New York.
The boss's wife?
Yeah, the boss family.
And their children. All right, this is what the court is going to do. The court is going to sentence you to 5 years deferred adjudication. If you're drug tested today, what are the results going to be? All right, there's going to be regular reporting by Zoom and in person, regular random UAs, a TAP evaluation out of custody, follow recs. We'll do a referral to felony drug court. Proof of employment within 30 days. No employment as a home health care provider or with minors. No contact with minors. Field visits 1 time per month until further notice. 200 hours of community service restitution. 140 sober meetings in 140 days. And take in consideration NIMAC number 761063. Probation, is there anything else?
You said 120 as far as service hours.
200 hours of community service. Yes.
Nothing else there.
Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. To be successful in this courtroom, communication is key. If there's an issue, let probation know. If you feel they're not addressing it, you can always come to court. And I will tell you, I'm not a doctor, but methadone, that's not supposed to be you're on it for life. You understand? So you're going to need to start doing your sober support meetings and getting with the sponsor. All right. I don't want you to be one of those persons who ends up in prison for the rest of their life, or somebody has to identify your body. You understand? All right. Good luck to you. You're
Thank you,
welcome.
Judge.
Thank you.
I apologize, I misunderstood my client, Judge.
Oh, no problem.
May I be excused?
Yes.
Thank you.
All right, everyone. The court is going on recess to.
And she cuts off the feed before she says what time. But I have already put up the next stream. It starts 3 p.m. Eastern Time, 2 p.m. Texas time, and and I will be back in about an hour and a half. So you all grab a bite to eat, hug your family, and then I will meet you back here in an hour and a half for Verdict Watch. Now, I will keep tabs, so if Verdict is in earlier than 3 p.m., I will go live immediately, okay? But thank you all for being here. Thank you for allowing me to do this. Thank you to Jude Curio for your $2 super chat. Thank you so much. Thank you so much. And yeah, I'm going to redirect you to the new stream so you can push the notify me other thingies. All right. Thank you again. Have a good one, and I will see you in 90 minutes. Okay. Bye-bye.